May be permitted to mention. And I'm praying for leave to file with the server copy of the order. But there are three applications.
438 or 439? Inclusion, just hand over the slip.
For correction, the order has been given special code Jalpaiguri, it should be Alipurduar.
To be mentioned tomorrow. To be mentioned tomorrow. The correction gulo dekhe nao.
Lord. And my lord, may I be permitted to mention one matter for upgradation, my lord?
Yes.
My lord, we have mentioned one matter, my lord, on Friday, my lord. And for with respect to medical emergency, Lordship was directed, let the matter come in the list and then further mention. Lord, the difficulty is matter is running in the list. Lord, the petitioner Lord, needs to go to Hyderabad for removal of a plate. Lord, he is in a very distressed condition, Lord. It's an anticipatory bail application, Lord. If you not could consider, I have also requested the state to be present that I am going to mention.
Sorry, sir, no, because we are not granting any upgradation.
Lord, I am.
We are not. Let us proceed. Who knows? We can reach the matter. Let us see. Call the list.
Lordship,
Inclusion, give it.
Lordship, one matter I would like to inclusion in the list with the
Give it.
leave of the Lordship. Actually, this matter is relating to appeal. We have filed an appeal on behalf of the state Lordship. There is a direction from the Justice Omniscient not to take any coercive action against the respondent Lordship. So being agreed against the order, we have preferred an appeal before your Lordship.
It will be listed. Give the slip. Give the number.
Lordship.
My lord, may I be please mention a matter? My lord, my senior Shubhranshu Basu had on earlier occasion mentioned about this case, but it was supposed to be listed today, but it did not get listed today.
Oh, the one he argued. Mr. Mojumdar is on the other side. DSG.
Yes, my lord, my lord, we were supposed to be.
Ashini listed. এই মিস্টেক গুলো প্রীতম কার মিস্টেক ইট উইল লিস্টেড টুমরো
Tomorrow, my lord.
কালকে আর মিস্টেক না হয়
Regarding to mention a matter for inclusion in the list.
গিভ ইট
Item number 1.
হোয়াট ওয়াজ সিজ মিস্টার পোদ্দার
Nothing was seized, and the registered owner, my lord. I am on interim bill. Many times interim bill was extended, all other on bill, my lord. Kindly confirm my interim.
হোয়াট ইজ দ্য স্টেজ
Lordship. Actually, co-accused was granted bail by a coordinate bench, and charge sheet has been submitted. So that Supreme Court.
you huh? Which one
Lordship remembers certain matters were there where Supreme Court SLP and other things, my lord granted bail.
charge sheets were submitted without FSL report
Lordship, here the co-accused bail was granted by a coordinate bench, and in subsequently another bench where this bail was moved. Then my lord opined that why did not we prefer any cancellation against that bail order?
I see
That is the matter, Lordship. So till now no report, Lordship, regarding what happened. All are
Yes, other co-accused persons bail are confirmed.
Yes.
issue. The petitioner was granted interim bail by an order dated December 4, 2023. Stop. From time to time, such order was extended. Stop. The order was last directed to be in operation till November 15, 2024. Paragraph, we have heard learned counsel for the parties. Stop. The petitioner has adhered to the conditions of bail. Stop. We are told that beyond filing of charge sheet, there has been no progress in the trial. Stop. Paragraph, under those circumstances, we confirm the bail, the interim bail on the same conditions on which the interim bail was granted. Disposed of.
For the.
State,
Kindly make it pass over. Pass over.
I am for the petitioner, my lord. My lord, I am in custody for 420 days. In this case, charge sheet was filed on 12th March 2024 without FSL report. My lord, till date, no
Yes, my lord.
charge has not been framed.
still not available, if it's.
No.
You have got a copy of our order? No.
How long you are in custody?
420.
420 days.
420.
You was arrested on 17th of September 2023.
How many days you said?
For 20 days to tell us.
420, said. Sounds better, not 420. The petitioner says that he is in custody for 420 days. Stop. The FSL report was filed within 180, the charge sheet was filed within 180 days, but without FSL report. Stop. Such a charge sheet is no charge sheet at all. Stop. He prays for statutory bail. Paragraph. Learned advocate for the state, comma, while opposing the prayer for bail, comma, candidly admits that the FSL report is not available even as of today. Paragraph 2 division benches of this code, এখান থেকে নিয়ে নাও। তারপরে এখানে paragraph 3 থেকে। হয়ে গেছে। না, হয়ে গেছে।
Item number 4, I'm praying for a short pass over lecture.
নেই কেউ। ও আছে।
Petitioner is in custody for 186 days, my lord. Charge sheet has been filed, my lord. Only 160 bottles of cough syrup has been recovered from this petitioner.
Only. 11 bottle is
I am
commercial.
praying for expedite.
Issue. Commercial quantity of fencidil
Yes, ma'am.
syrup containing codeine mixture, কি বলে codeine mixture, না? Was allegedly recovered from sole accused
No, my lord. 3 accused, sir.
from
Even for the-
from the joint possession of the accused persons, including this petitioner. Stop. Commercial quantity of contraband items being involved, comma. We are not inclined to entertain the petitioner's prayer for bail. Paragraph. However, comma, the petitioner is in custody for 186 days. Stop. Beyond charge sheet file.
Yes,
Fine, with savers.
Beyond filing of charge sheet, comma, there has been no progress in the trial. Paragraph. We request the learned trial court to expedite the trial to the extent possible and conclude the same on an early date.
Item number 6, I'm appearing on behalf of the petitioners, your lordship. The petitioners are languishing in custody for 5 months, 15 days, your lordship. From their possession, your lordship, 10 bottles of RC cough syrup has been recovered, your lordship. The commercial quantity is 1 kg, your lordship. So 100 ml bottles into 10 is 1000 ml, your lordship, which is lesser than 1 kg. Because of the velocity, your lordship, it would be lesser than that. So that falls under the intermediate quantity. Along with that, 561 pieces of spasmoproxivin plus, your lordship. In that case, your lordship, tramadol 250 gram is the commercial quantity as per the NDPS Act, your lordship. But it falls within that category. So that is also within the periphery of.
Yes, Mr. Ganguly?
Lordship, I say that 1000 ml millicentimeter decat to kilo, so 1000 ml equal to 1 kilo. So it's,
The bottle has a weight also.
no, Lordship, the content is 100 ml.
Oh, I see.
So 1000 ml is 1 kilo, so it's,
Charge sheet filed.
no, Lordship. Monitoring is not completed yet.
Monitoring is not complete, your lordship.
The investigation is going on.
Your lordship, but for
But what?
instance, the oil, the packet of
No,
a
it
master.
is admitted
your
position.
lordship,
It is a commercial quantity.
Yes, Lordship, we
If it
say
is
it's
a-
a commercial.
Yes, if it
But
is
if
a
1000 ml equals to 1 kilo.
No, your lordship.
Madam, we are not going to attend to this application. You want,
The earlier matter, if I could
If
quote
you-
my learned senior from the state, they had stated that 11 bottles is the commercial quantity. So because it is considered to be the with the velocity of the liquid, your lordship, for instance, the mustard oil, your lordship, a packet is not 1 kg. It is 940 ml, your lordship. In the similar periphery, your lordship.
Madam, even assuming it is intermediate, does that automatically qualify you for bail? Is that the law?
Lordship, the
And 180 days has not been expired yet.
One
the bar-
investigation is going on.
bar of 37 would not
You want to
like
suffer a rejection, then issue.
your lordship. the bar
The petitioner says that
Permitted to not press then your lordship this because 180
we
days.
shouldn't allow you because you have wasted 5 minutes,
I apologize.
not pressed.
Item 3, madam.
Yes.
Subsequently, IO is present, madam. Subsequently, CFSL report and supplementary charge sheet filed. Court noted as
Oh, so as of not
item 3,
available.
item 3.
Hey, not available as of today, বলছো না? দেখো তো। Learned advocate for the state while opposing the prayer candidly admits he ওটা হবে না। Candidly admits রেখে দাও। Says that subsequently FSL report was filed.
With supplementary.
Subsequently, supplementary charge sheet was filed along with FSL report. ঠিক আছে, তারপরে কি লিখেছিলেন? সেম হবে না তো? হ্যাঁ, ঠিক আছে, ঠিক আছে, ঠিক আছে। 7,
Not today.
not today.
8.
But this two petitioner is custody more than 270 days. And only 65 bottles of cough syrup is recovered, joint possession and so
You have suffered rejection
this is
1st of August.
this is before charge sheet at this stage that is rejected. At that time charge sheet not submitted. Now charge sheet submitted on 3rd August 2024
Commercial quantity.
without FSL report.
Charge sheet submitted when?
When August kindly see page 13.
No, charge sheet submitted when?
3rd August.
3rd August.
Without FSL.
Yes.
Still not available FSL.
No.
Hey, কি করা যাবে? We are helpless, Mr. Ganguly. The petitioners renew their prayer for bail, which was rejected on August 1, 2024. Stop. They say that on August 3, 2024, charge sheet was filed, but without FSL report. Stop. Such a charge sheet is no charge sheet in the eye of law. Stop. They pray for statutory bail. Paragraph, learned state advocate while opposing the bail prayer in view of commercial quantity of contraband being involved, candidly admits that FSL report is still not available as of today. Paragraph, তারপরে ওই যেটা two division.
Yes.
State,
But previous rejection on the ground of violation of NDPS rules and section 42 of NDPS Act, which was found to be duly complied as per the submission of statement. But I am coming on a different ground, that is submission of charge sheet without FSL report.
When was charge sheet submitted?
Charge sheet was submitted 10th July 2024.
Yes,
In February
Mr.
2024.
Mr. Vishwas, is that correct? Without FSL report?
Yes, Lordship.
Still not available, FSL?
Lordship, if now available,
Has it been filed with supplementary charge sheet?
Lordship, let me.
I thought I am relying on one judgment, my lord's judgment, that is Idul Mia. And
Lordship, the report has been received, it's confirmed. It's confirmed the presence of heroin.
Have you filed that report with supplementary charge sheet?
Not, I think we'll be submitting it. Since the original CD is here, Lordship.
Once the right of statutory bail accrues, we have to give it.
Statutory bail has to be availed of. Lordship. For the improving judgment, it has to be availed of by filing a petition.
my lord, in
They have filed the petition before us.
Yes.
Before us. This one, we'll treat this.
I have a
Mr.
different
Numbers,
interpretation, however.
judgment.
issue. No, but as a matter of fact, has it been filed, the supplementary charge sheet?
Lordship, I will put that. Sashi to দেখছি যে রিপোর্টটা আছে
Lego. The petitioner renews his prayer for bail, which was rejected earlier on July 24. 2024.
Yes,
Stop.
24th July.
Stop. He says that,
Next date is fixed for filing of chemical examination report, Lordship. That means with a.
which means it has not yet been filed. কি বললাম? He says that the charge sheet was filed on
10th July 2024.
when was he arrested? 180 days have gone, Mr. Vishwas.
January.
13 January.
January.
On July 10, 2024, but without the FSL report. Stop. Such a charge sheet is of no value. Stop. He prays for statutory bail. Paragraph. Learned state advocate, while opposing the prayer for bail on the ground of commercial quantity of contraband being involved, comma, candidly admits that the charge sheet was filed without the FSL report. Stop. However, the FSL report is now available, and the report and the samples have tested positive
Yes.
for the presence of contraband heroin. Stop. However, comma, the FSL report has still not been filed. Stop. Paragraph. Okay. Yeah, 2 division benches have held. Huh?
Petition Kazi 286 days.
ওইটা একটা জায়গায় দিয়ে দিও অপূর্ব। The petitioner is in custody for 20.
Sure, for the petitioner. Should be NDPS case. He was arrested on 1st March 2024, that is 255 days in custody. Charge sheet filed against 5 persons was arrested, 2 absconding, still absconding. So next date is on 27/11/2024 for EROWA of those 2 absconders. Lordship, I pay my bail application on the ground of non-compliance of statutory provision of 42(2) of NDPS Act. In this regard, Lordship, I place the judgment of my lords only that after search and seizure and after getting the intimation, it has to be in writing informed to the superior officer within 72 hours. Lordship, as the order I have placed, Lordship's order.
We will have to decide this, all these breaches, whether they totally dilute section 37 or not.
May I?
That we will decide. We have a case. DSG is arguing and for the petitioner.
Lordship, I have replied to that DSG's because he is citing Nawaz Khan, which has already been diluted subsequently by 3 judges member of Supreme Court in Arimuthu, Pallavi Arimuthu.
Anyway, now we have to follow this for the time being.
Yes.
Yes, what do you say?
Commercial quantity of minor brown sugar.
Yes, but 42 not complied with. Issue. Hey, আমাদেরই order আছে। The two petitioners. The petitioners say that they are in custody for
Lordship, custody of 255 days.
255 days. Stop. এই যে, তারপরে সেম ডেটা ছাড়া কাস্টডি সব সেম
Careful, Lordship. You allow for the petition. So this is a different footing. Kindly see page 18 of my petition, Lordship. This is a list dated 25/9/2024. Page 18, which says date of seizure, Lordship, and the time of is 14:05 hours to 15:10 hours. That is 2 p.m. to 3 p.m. Place of seizure, Balapara Tata Motor Service Station under Kotwali PS. It's just near here.
Yes.
Now, kindly see page 19 and 20, Lordship. If the seizure was on that very place, the accused persons ought to be apprehended in the said place. Now, kindly see page 19 and 20. There is 2 arrest memos. Now, kindly see column 10, signature of witness. Signature of witness, either a member of family or respectable person of the locality. It is Balapara NH 31 in front of Tata Motors. There are Tata Motors service center out there. And see the signature of the witnesses, that is either a member of family or respectable person of the locality. This is the person who has signed.
Yes.
It is mentioned intimated to the local PS through mail to the family members. No signature whatsoever of the any person present out there. No signature of any person present there, be it respectable or any.
Yes.
In this regard, I
Yes,
place
yes.
my lord's order
Holding the memo of arrest and as well as the
reported.
email, my lord.
No, you just tell us this. What he says is correct. There is no signature of independent witness on the arrest memo.
Mail, my lord.
Huh?
It was intimated to the local.
That is not what the law says.
So she have given the judgment of my lord's order reported in SSC.
Pending, pending, my lord, and commercial quantity.
All understood.
Yes, my lord.
দেখি দাও কি আরে ওটা না তো
Lordship's order. Fortunately, I was the advocate moving the has been reported.
Oh,
DK Basu, complaint DK Basu. Para 1.
this is the requirement of column number. Column number, this is a requirement. That requirement is to be complied. It's not a mentioning that we have intimated you or intimated so and so.
Why do your officers do like this? We don't understand. You think we are happy to grant bail? We are not. এসো, এসো। Oh. The petitioner says that he is in custody for
Worship, I was arrested on 25th 9 2024.
tell us how many blank days. Petitioners say that they are in custody for custody since September 24, 2024. Stop. They say that their arrest is wholly irregular. Stop. The arrest memo does not contain the signature of an independent witness. Stop. Against column 10, it is merely stated, colon diye e koro, quote koro, intimated against column 10, যেখানে ব্র্যাকেটে দাও, signature of witness. Bracket closed, comma, it is merely stated, colon, in quote koro, intimated to the local PS through mail to the family members. Stop, unquote. Stop. This does not satisfy the requirement of law. Stop. Hence, the petitioners should be enlarged on bail. Paragraph. We have heard learned state advocate. Stop. We have seen the material in the case diary, including the arrest memo. Stop. Indeed, comma, there is no signature of an independent witness as is required against column 10 of the arrest memo. Paragraph. Accordingly, comma, we are constrained to hold that the petitioner has been able to overcome the restriction under section 37 of the NDPS Act. We therefore allow the petitioner's prayer for bail. Prayer for bail.
Keep level.
Stop. Prayer for bail. Stop. The petitioners shall fully cooperate with the investigating officer.
Keep level.
I'm for the state.
Mr. Mujumdar, Mr. Shudipta Mujumdar, it's our fault that the matter where Mr. Shoptangshu Basu was appearing, it was directed to be listed today. It has not been listed. It's a mistake. It will be listed tomorrow. You won't be here tomorrow. You will be here. Yes.
What happened there? Police intercepted and they're saying that four plastic bottles recovered and reddish color of liquid. The lordship can is the case 10, my lord. Case 10 of qualification. From line number 4, my lord. Also apprehended Shahrukh Khan also bagged as well as recovered 4 number of plastic bottles. Each bottle containing 500 ml containing liquid reddish in color suspected to be cough syrup containing codeine phosphate. Madam, the same plastic bottle containing reddish in color. Madam.
One second. Hey. Yes.
Saying that one is found 4 bottle of plastic bottle 500 in and reddish color in liquid. In the bottle there is no labeling, nothing. There is no primary satisfaction. This is stock.
How long are you in custody?
3 months.
3 months. 3 months. Madam. Another thing, this is the ground on the ground, and another thing is that my wife, it is my wife is pregnant, my lord, and submitting document, my lord, expected to be delivered in month of my lord, January, my lord. I am paying interim bill. I am relying on coordinate benefit now also, my lord. The lordship granted
What
interim
that
bill.
if the wife is pregnant, then bail has to be granted. That is the decision.
My prayer, My prayer, my lord.
The investigation is still going on.
Any
going on.
decision which, any
Yes, my lord,
decision.
institution is
My lord, what they did, my lord, they have, my lord, taken out the cough syrup and put it in a 500 ml bottle.
Obviously, FSL report is still not available.
Still not. Early stage of investigation.
Fine.
But we have asked for the report.
We are not, no, you can renew it later. Now we are going to reject it. Do you want to suffer a rejection? Huh. Closer to the date of delivery, maybe you can come, try your luck.
No, I'm for the petition.
15 state.
So 26/9, it was last rejected.
Yes.
Any, what is the development?
Till to the charge not framed. I have had custody 555 days, my lord.
Charge not
Till
framed.
Charge not framed. And the charge sheet submitted without FSL, thereafter after many months.
Charge sheet submitted without FSL.
After many months, supplementary charge sheet with FSL, my lord. There is no extension by the learned court or anything, my lord. Till today, 555.
How many witnesses?
My lord. My total 16 witnesses.
16.
16 witnesses.
Articles 18.
How long you are in custody?
555. 555.
Long detention. Yes, Mr.
Why not?
Gupta.
Yes, my lord. Charge was not in
What was
fact.
recovered?
State is fixed for 4/11/24.
What was recovered?
My lord,
58% of cough syrup,
58
30 pieces of injection.
my lord, kindly look at the supplementary charge sheet.
Why, tell us what you want to show.
Supplementary charge sheet was filed, my lord, on 21st to 2024. Articles recovered were, my lord,
We are on delay,
14
Mr.
for
Luxem. We are on the delay aspect.
it's not delay aspect is there, my lord.
Issue. Commercial quantity of contraband items was allegedly seized from sole accused,
Two accused, my lord.
from two accused persons, including this petitioner. Stop. His prayer for bail was rejected on September 26, 2024. Stop. He renews his prayer for bail on the ground that although he is in custody for about 555 days, more than one and a half years, bracketed down, more than 1.5 years, comma, charge has not yet been framed, although charge sheet was filed on.
Supplementary charge sheet, my lord. Come back to.
No, initial charge sheet
Initial
was
charge sheet was
Charge
filed
sheet
on
on 28 October 2023.
October 28, 2023. Stop. He prays. He says that on the touchstone of Article 21 of the Constitution, comma, he should be enlarged on bail. Paragraph opposing the bail prayer, comma, learned state advocate says that supplementary charge sheet was filed on
supplementary charge sheet was filed
February
21st February 2024.
February 21, 2024, along with the FSL report. Stop. The samples have tested positive for the presence of contraband items. Stop. All efforts will be made to expedite the trial. Paragraph. The petitioner is in judicial custody for more than 1.5 years. Stop. Even charge has not been framed. Stop. There are 16 witnesses named in the charge sheet. Stop. It is anybody's guess as to when the trial will conclude. Stop. And under trial cannot be kept in incarceration for an indefinite period of time. Paragraph. Without commenting on the merits of the case and solely on the ground of lengthy detention of the petitioner, coupled with the fact that there is no possibility of an early conclusion of the trial, comma, we are constrained to allow the petitioner's prayer for bail. Yes,
And for the petition, Your Worship.
16 you are appearing?
Yes, my lord.
Lordship, my bill was turned down twice prior to this. First, charge sheet was submitted without FSL. Honorable Court gave time of 1 month to the state to submit the same. And my bill pair was,
When was that?
Lordship, page 15. Page 15. No, Lordship, sorry. Lordship, may I? Lordship, this is page 29. And subsequently, Lordship,
Page?
Lordship says page 10 first. Para 5. That is page 11, para 5.
That is 23/7.
23/7.
Yes, right.
Next, Lordship, page 12. We have filed once again as because the FSL was not filed. But during hearing, Lordship says para 13, the para starting from in such view. Page 13. From bottom, para starting from in such view of the matter.
Yes. Yes.
So as because liberty was granted, FSL was filed, so my bail prayer was not entertained. But Lordship, the main point is that without FSL, when the charge sheet was filed, my statutory right, which is an indefeasible right, has not been considered. It was not been pleaded even or considered.
So
So,
at this stage, you see, a division bench has made some observation.
Lordship,
We
that is the
cannot-
reason I have.
So you ought to have gone before the apex court against that order, if you are agreed. Now, what are the other grounds regarding trial and all these things?
Till now, nothing happened.
How long in custody?
Lordship, I'm in custody for 325 days.
Just less than a year.
Lordship, charge sheet was submitted on 176 days, only to curtail my right. Subsequently, supplementary charge sheet was submitted on 292 days with FSL. In meantime, my bail was turned down. My statutory right was curtailed.
Ganguly, we cannot, in the face of this observation of the division bench, we have a different view,
Lordship.
but we cannot
Lordship.
go higher up.
Lordship, can you appreciate I have mentioned the paragraphs even?
Yes. So any other ground, we will generally expedite. What
Regarding
else?
that, we cannot touch.
Lordship.
Your remedy lies
Lordship.
before the.
Lordship, till now, in custody 325 days, even the charge has not been framed.
When is the
How
next
many
date?
witnesses to be examined?
My lord, 9 total witnesses.
Total?
9.
14
14.
14 witnesses.
14 witnesses.
When is the next date fixed?
Lordship, one co-accused has been enlarged on bail.
Coacus, there was no recovery from him.
No, recovery.
Oh, there was recovery. Yes,
Recovery.
what is that order?
Lordship, he was on a different footing, Lordship. He was medical ground, he was by but he's enjoying bail,
No, that's all right.
in interim bail by the trial
Which
court.
date?
My lord, in my lord, memo of evidence, my lord, only regarding supplementary charge sheet has been filed on 5/9/24. Next date of trial not mentioned.
No copy served even. Co-accused is
I'm waiting for
enlarged on bail.
explanation, sir.
Who said what you No, we don't. We'll grant interim bail and then we'll see how it goes. The petitioner renews his prayer for bail, which was rejected twice on July 23, 2024 and September 4, 2024. Stop. He says that the petitioners of it, they say that they are in custody for 325 days. Stop. Even charge sheet has not been framed. Charge has not been
Copy
framed.
has not been supplied.
Copy not supplied. 207 copy is not
No.
supplied. That is, आगे देखो, even copies under section 207 CRPC have not been supplied. Stop. There is no possibility of an early conclusion of the trial. Stop. On the ground of delay in trial, they pray for bail. Stop. They renew their prayer for bail. They renew their prayer for bail. Paragraph. They further say, that a co-accused person has been granted bail. Paragraph. Learned state advocate, while opposing the prayer for bail, says that the person who was granted bail stood on a different footing. Stop. He was granted bail on medical grounds. Stop. Supplementary charge sheet has been filed on
Filed on
292 days.
290.
on blank
5/9/24.
on September
5/9/24.
5920.
September 5, 2024. Stop. The FSL report, which was filed with the supplementary charge sheet, shows that the samples contain contraband items. Stop. Paragraph. The prosecution may have an excellent case to secure conviction of the petitioners. Stop. Nobody stands in the way of the prosecution doing so. Stop. However, we find that the petitioners are in custody for about 11 months. Stop. There has been absolutely no progress in the trial. Stop. Copies have not been supplied under section 207 CRPC, let alone framing of charge. Stop. Paragraph. Solely on the ground of lengthy detention of the petitioners without there being any progress in trial, we are inclined to grant interim bail to the petitioners. Accordingly, করে যা বেলের order করে দেবে, তবে next করো. This order of interim bail shall continue till December 20, 2024, or until further order, whichever is earlier. Stop. List this matter before the next
Deep level.
circuit, next available circuit bench.
Deep level. Lord, 17, I appear for the petition. Lord, the custody is 62 days. Why I have come up before your lordships is because, Lord, at the time of bail hearing before the learned trial court, one thing had come up, which is that, my lord, the samples were sent to the, my lord, FSL before certification by the magistrate. My lord, on that regard, my lords will kindly satisfy yourselves from the case diary, if that is so, my lord.
My lord, certification was done on
25th of September 2024. 25th of September. As per receipt of the CFSM, that is of page 106. Just a second.
This is 52A.
Yes, 52.
Not 5 days before the certification. 20th of September 2024.
Receipt. Then certification is a safeguard.
Yes.
Madam, covered by your lordship's judgment.
কি করবে ওরা তো দিতেই হবে।
Not
The-
commercial quantity, huge quantity of
You
ganja.
tell us what is the way out.
That is the fatal.
Yes.
Okay.
We are repeatedly saying we don't feel happy granting these bails, but what to do? Esho,
Not kindly note our objection.
of course.
200 kg ganja.
The samples were sent to FSL prior to certification by the concerned magistrate. Stop. This is gross infraction of the provisions of section 52 capital A of the NDPS Act. Stop. He prays for bail on that ground. Stop. He relies on an order of a coordinate bench, or no, of this bench, passed on October 4, 2024 in CRM NDPS 444 of 2024. Paragraph. Learned state advocate, while opposing the prayer for bail, says that 200 kgs of ganja was seized from sole accused, the exclusive possession of this petitioner, who is the sole accused person. Stop. However, comma, in his usual fairness, comma, he says after consulting the case diary that the sample was sent to the FSL by the investigating officer even before the same was certified by the magistrate as required under section 52 capital A of the NDPS Act. Stop. Paragraph. We have also seen the material in the case diary. Stop. It appears that the FSL received the samples on September 20, 2024. Stop. The concerned judicial magistrate signed the certificate on September 20. Acha, tale was not received, was sent by the investigating officer on September 20. Sent by the was sent to FSL, to the FSL by the investigating officer on September 20, 2024. Stop. However, the concerned judicial magistrate signed the certificate on September 25, 2024, IE, after the sample was sent to FSL. Paragraph. In view of breach of the mandatory 25, not 27, karo. Paragraph. In the order dated October 4, 2024, relied upon by the petitioner, we had referred to a decision of the Honorable Supreme Court in the case of Muhammad Khalid and another versus State of Telangana, reported at 2024 5 SCC 393. In support of the submission that the provisions of section 52 capital A of the NDPS Act are mandatory in nature. Stop. Without compliance of such provisions, the FSL report would be an useless piece of paper and cannot be admitted in evidence. Paragraph. In view of breach of the mandatory provisions of section 52 capital A of the NDPS Act, and in view of the aforesaid Supreme Court judgment, we are constrained to allow the petitioner's prayer for bail. এটা থেকে দেখে নিও বানানটা নিজের।
Not in 18, I appear for the petition.
State. Passover, not today, whatever,
Not today.
not today.
Item 19, I'm praying for not.
20 lordship praying for not one day accommodation.
My lord, it was fixed on Friday, my lord. It was, they prayed for time. Today it's fixed again.
Next.
21. 21.
Nahi.
22.
State not there.
21.
20?
21.
State 21 state. No CD, not today.
Both were fixed on Friday, both were CD were not present. Today again, same thing. Did it be fixed?
Tell us what should we do? Tell us. Tell us what we should do. Not today.
They have filed, but the copy was served on Friday, so.
22.
State. Yes, not today. Not today.
It is very.
My lord, 23, I'm praying for short Passover, my lord.
Chalo.
24.
24 state.
4.
Not today.
25.
Yes.
Actually, this is a perfect example why section 42(2) has been made to be complied by the legislature. Kindly see page 15 of my petition first. The seizure list.
Yes.
Place of seizure, that is to Nandala Road near Dalmore Railway Station. Is the Dalmore Railway Station, Lordship?
Yes.
Now, kindly see page 17.
Yes.
Memo of arrest. Point
Yes.
number 2, para number 2, B, place of arrest. Kindly see the place of arrest. That is the reason, Lordship, no 42(2) has been complied. No intimation to the superior was sent by the IO.
Signature of witness is there.
Signature, but place from where I have been arrested. In PS, they have taken the signature of these persons, and that is the reason for no 42(2) has been complied, Lordship. Because if superior was intimated, the IO would have been in trouble.
This is very big.
Only 20 bottles.
No, 42 people independent. 42 হচ্ছে তোমার জামাতে রয়েছে।
Superior officer, 41.
CRTC.
No, CRTC. Wait,
এই CRTC এই যে ওনাকে দাও।
14B is signature of independent witness.
Seated 41.
My submission is, Lordship,
42 my lord, on compliance.
Oh, okay. 41B. B beat. এটা complain. Place of arrest কত 41 B থেকে 42 এর ABCS
42(2) of NDPS Act যেটা
NDPS Act.
informing the superior officer.
That is the
That has
reason
not
it has
been
not been complied because I was
Because of the
arrested
place
in
of arrest,
PS.
my lord, it is blank.
Sure. And that is also mandatory.
Lordship.
What is the case? We have passed orders on
Yes,
that.
Lordship. 42 order. Lordship, I have the order.
What was seized, Mr. Luxem?
Lordship, in
What was seized? What was
20
seized?
bottles of coffee.
20 bottles of course. Lordship, in Jagraj Singh Hansa as well as Bhuta Singh. Supreme
8
Court
grams of
decided it mandatory.
8 grams of brown sugar was also seized, my lord.
Jagraj Singh, they took
8
also
grams.
8 grams.
That is.
That is much below control.
940.
This is Jagraj Singh Hansa and this is Bhuta Singh. In both of them, Supreme Court has said that it's mandatory.
Our order, we have referred to this.
Yes. Himmat Singh. Himmat Singh. Lordship, I have only one copy. Himmat Singh. This is the order.
Issue. The one petitioner,
Lordship, and the copy.
the petitioner says that he is in custody for
Lordship, I'm in custody for 174 days.
174 days. Stop. He prays for bail on the ground of non-compliance with the provisions of Section 42(2) of the NDPS Act, 1985, which reads as follows. 42(2) Paragraph. Learned counsel relies on a coordinate bench decision of this court in the case of Abdul Rakib, এখানে আছে দেখে নিও. In support of his submission, he has also placed before us a decision of the Honorable Supreme Court in the case of Bhuta Singh and others. এটাও আছে এখানে দেখে নিও. Paragraph. Learned state advocate says that commercial quantity of fencidal syrup containing codeine phosphate was recovered from this petitioner. Stop. However, in his usual fairness, he admits that there was non-compliance with Section 42(2) of the NDPS Act. Paragraph. We see from the judgment cited before us that Section 42(2) of the NDPS Act has been held to be a mandatory provision. Stop. Non-compliance with such provision is liable to render a conviction bad. Paragraph. In that view of the matter, since admittedly the provisions of Section 42(2) of the NDPS Act were not complied with, the restrictions in Section 37 of the NDPS Act, 1985 stand sufficiently diluted. Paragraph. We therefore allow the petitioner's prayer for bail accordingly. এটা থেকে কেসগুলো দেখে নিও.
For the statement. Not to be done.
27, 28,
Co-accused granted bail, Lordship, one day account.
29,
Kindly make it not.
30,
30, my lord, I am for the petition. Lord, I am claiming on parity, my lord.
No CD.
31,
But kindly fix it on Wednesday.
I could have tried to help you. There's no CD. There's one CD in my chamber. That's an audio CD.
31,
Or kindly.
I am
figure out
waiting for
what
this
is it.
What?
Wednesday, my lord.
Wednesday.
32. My lord, I am not.
My lord, petitioner was arrested.
Huh?
Petitioner were arrested on 24 February 2024.
Yes.
My lord.
Four petitioners.
4 petitioners.
Hmm.
My lord, today is 259 days. My lord,
What was seized?
sees
7.247 kilos of Java tablet, commercial quantity was above 15 grams,
Oh, wow.
huge quantity.
my lord, there was a violation.
Joint
of the
position,
section-
joint position.
Yes, where is the seizure list?
My lord, Rule 14 violation. My lord,
No violation.
Rule 14 violation. My lord, chemical,
No, these
articles were
recovered from any vehicle, from the house. Seized from the conscious position of all these 4 persons. From the personal
Yes,
position,
sir.
yes.
my lord, kindly see the sample was received FSL
On 1st of March 2020.
29 February 24. My lord, report was prepared.
No, they were seized, but from which accused persons?
From joint position.
Joint position means where, how, what is joint position?
They were together, my lord. They were
Together
carrying-
where, in any vehicle or where?
Second there, my lord. in the second.
Where?
From whom seized, from where seized? My lord, 4-month delay.
Gopal temple.
My lord, 4-month delay.
But CFL, it was sent on 29th of February 24.
My lord,
অ্যাকশনে ধরা হবে কোনটা ইন্ডিভিজুয়ালি তো ধরা হবে পাঁচজনে যদি একসঙ্গে ক্যারি করে আপনি যে ভাঙ্গপাল টেম্পল ভাঙ্গাপাল কি
my lord, 4-month delay for chemical
So
examination.
you're relying on that order passed by
My lord,
Justice
my lord.
Bhattacharya possibly.
My lord, I submitted the citation. My lord,
That is not mandatory, madam, it's just.
my lord.
We think so.
Ali.
It's our view, but
My
what
lord.
if a division bench has held that it is
My lord
mandatory?
also-
My lord, it was, the CFL was sent on 29th of February. The case was of 27. After the correction is 24th, my lord, after the
Chakraborty,
correction, it was sent within
Mr.
time it came.
Mr. Chakraborty, Rule 14, if I remember correctly,
My lord.
says 15 days and 15 days.
My lord, 4 month, my lord.
Here, my lord, it was received by them on 1st of March
Yes.
2024. And report was dated 24th of July, it's fact.
Correct.
But within time, they have filed the.
That is all very well, but if on that ground a division bench has granted bail, saying that we may not agree,
Also rejected, but I have the order.
show us,
I'll just give you my lord one.
show us,
My lord also
Because
passed.
in my case.
help
that
us to
was-
reject.
My
That
lord
was the last order of
also
justice, my lord,
passed.
Honorable Justice Bhattacharya, that was the last order where he has rejected, though there was a delay of 3 months. my lord.
Show us.
I'll show you.
But was this point raised?
Yes, my lord.
Rule 14 was raised,
Yes, my lord.
not today. Sir, we don't subscribe to that view with great respect, but a division bench staring at us, let us see what Mr. Chakraborty produces.
My lord also, Mohammed Khalid, state of Telangana.
You're in custody for about 9 months.
253 days.
Charge sheet has been filed. Next date is fixed for production, 12th of November. Tomorrow is the date fixed.
My lord, charge sheet filed, but till to date not charge was
Filed
paid.
23rd of July.
Also Robi
Come back
Kishan, my
tomorrow.
lord.
Come
Robi
back with
Kishan,
the-
Tomorrow, my lord.
Come back tomorrow.
my lord.
33.
Item number 33, I'm praying for not to.
34. 34.
My lord, 34.
34
My lord, I am for the petitioner. My lord, 17 kg of ganja recovered from the joint possession of 3 accused.
How
My
long
lord,
in
I am
custody?
only one.
Only 42 days, my lord.
Huh?
Statutory report not over, only 42 days.
42 days in custody.
My lord, 40.
Initial stage of investigation. Very immature.
So, no, is it intermediate quantity?
It is intermediate.
17 kilos,
Intermediate.
20.
My lord, joint possession.
Discretion. Okay. Discretion. This is Sahan for every decision to the tax lucky. NDPS actually. NDPS actually.
Yes, in case of intermediate quantity, what is the statutory period?
60 days, my lord.
60 days.
60.
How long is in custody?
Only
My lord, 42 days, my
Prosecution
lord.
should get a chance, my lord. Investigation is going on. Other names may come, my lord. If they're not.
Closing for a issue.
Ah, my lord. This is not.
My lord, 42 was not complied.
Huh?
42 was not complied, my lord.
Which portion of 42?
My lord, the 42 surplus 2, my lord,
Was not complied.
not complied.
Yes, Mrs. Chakraborty?
My lord, the
Not informing the
intimation not
superior
given the,
officer.
intimation not given within 72 hours.
Then I have to call the IR, my lord. Because what happens, my lord, some intimations are done through mail also. So in that case, my lord.
Find out, find out.
Yes.
Not today. No, sir, sorry, আমারই ভুল ধারণা ছিল। উনি intermediate হলে ছেড়ে দিন। Commercial হলে
আমি 37 এর ওটা কাটছে না।
35.
Lordship, I am for the petitioner, Lordship.
35.
State.
Contravened was seized from the possession of Ilyas Hussain. I am not the Ilyas Hussain. I am Sharun Thapa, Lordship. On basis of co-accused statement, my name.
Caesar. Caesar list.
I think you have annexed the Caesar list.
My lord,
I have the copy of the Caesar
I
list.
have the Caesar list, my lord. From his position, on the basis of the leading statement of the two accused, yes.
So principal accused is in custody.
Principal accused.
Yes, Lordship.
One, Ilyas Hussain, he is the principal accused. On the basis of his statement, one Ramjanam Singh was arrested. On the basis of Ramjanam Singh has statement, Supriya Rahman was arrested.
Tufan
And
Singh.
then Saran Thapa was arrested.
Tufan Singh.
Tufan.
The, how long in custody?
142 days, Lordship.
Charge sheet?
Lordship.
Charge
Charge
not
not.
filed. It's a case of 22nd of June.
Commercial quantity.
Time আছে তাহলে the petitioner says that he is in custody for 142 days. Stop. There was no recovery of contraband items from him. Stop. He has been implicated solely on the basis of statements made by co-accused persons. Stop. He prays for bail. Stop. Paragraph. Learned state advocate says that commercial quantity of ganja, no,
Lordship, cough syrup.
of cough syrup containing codeine phosphate was seized from the accused persons, including accused persons. Stop. However, there was no recovery from this petitioner. Stop. It is true that this petitioner has been implicated on the basis of statements made by co-accused persons. Paragraph. In view of the aforesaid, we are of the opinion that the restrictions in section 37 of the NDPS Act stand sufficiently diluted, entitled, stop. On an overall assessment of the materials on record, we are of the view that it may not be necessary to continue the custodial detention of the petitioner.
Along with 144 number of cough syrup, another 2736 pieces of.
We have just said commercial quantity. commercial quantity of Syrupta and Yaba tablets. Yaba tablets.
SPM
Wait, wait.
SPM-PRP.
Tablets. At Kurele. 35. Yes.
36.
Lordship, I'm for the petitioner in item number 36, Lordship. The commercial quantity of contraband, that is brown sugar, was seized from the three accused person. I'm one of them, Lordship. I'm praying for bail for two reasons, Lordship. Firstly, the certification of inventory has not been done by the investigating agency, Lordship. This is the first thing. And second thing, there is a
Sample has been sent without certification.
Lordship. And secondly, Lordship, the CFSL report that was received by the concerned laboratory on 6th May 2024, and the report has sent on 39 2024, that is after 4 months, Lordship. And rule 14 of the NDPS rule says that it has to be done as expeditiously as possible, Lordship. So at this juncture, I'm praying for bail and placing reliance on two orders of two coordinate benches, Lordship.
Yes, certification in order.
And it is saying, and everything is when your lordship, you don't look at the need lordship, just we can decide lordship. But here it is totally clear that kind of we only consider at the time of trial, not at this stage, your lordship. But I will invite your lordships.
Show us the certification
Sir,
and tell us when was the sample sent.
sample sent first memo of arrest.
Lordship, sample was sent on 6th.
But inventory made on 30/4/24, your lordship. And same sample 6/5/24, your lordships. 6/5/24. And the inventory is intact, your lordships.
When did the magistrate certify?
Certified. Upon administration intact, your lordship. And we like verdict sheets cases.
So judicial magistrate second court was required to certify. Where is that certification by second court? Which page? Because CGM referred the matter to second JM.
Yes, yes.
So it is the second JM who is to certify. Where is the certification?
Sir,
by
please,
second
please,
JM?
please find out the material. Do not hold us up.
And Lordship, there is another order of the
Come
coordinate
back,
bench.
come back tomorrow.
Lordship.
Please prepare yourself. Please. Time is precious. Please.
Obliged, Lordship.
Dear, bring it tomorrow.
So all the cases. Order the order.
Thank you.
37.
Paying for not to take it.
38.
Time for the petitioner. Well, it's tomorrow then. And
39.
my lord, time for the petitioner in 39.
40. 40.
State who is appearing.
State here.
41.
Not today.
41. We are after the state. Otherwise, my lord, because in this type of case, my lord, it's a brutal murder, my lord.
Yes, 164 statement.
Page 215, 216, 232. There are three, page 215, my lord.
Mr. Chakraborty, how many accused persons?
Accused, there are total 1, 2, 3, 4, 5, 6 accused persons have seen the bill.
How many out of them?
These accused persons, they are all co-accused, my lord. Principal accused is this person. He is the principal accused. Against them,
There is 120B.
120, maximum 120 against the others. But he is the person who has committed the offense. my lord. He is
Anyway,
the person.
case was initiated under 363, 365. Thereafter, 302 was
My
added
lord, She was found. thereafter.
when the body was
My
found.
lord.
If others have been enlarged on bail, in spite of there being 120B,
Anyway, in this FIR, now this person's name did not appear.
At the initial stage, there was no doubt about regarding this person. That's why his name was not in the FIR.
So,
After investigation came on his leading
Yes.
statement, and all the things has been recovered. And on keeping the, on the arm, on the shoulder
are
of this person, other persons have obtained bail. my lord.
we are not acquitting him.
My lord, until and unless there is a custodial trial, thing is
Why?
that.
Why? Justify it.
My lord, in this type of
Yes.
cases, there's every possibility of tampering of it, because they are of the same locality. Just
They will-
saying
they
that
will-
she will be out of the locality, my lord,
Yes.
that will not serve the purpose.
Why will it not serve the
It will,
purpose?
my lord, it will, why they will influence. my lord.
actually, police authorities are the main witnesses on who have interrogated and recovered the weapons. Okay.
Yeah, independent witnesses whose presence the weapons were recovered. They are
Yes,
there.
yes. That is there, but the main recovery was done by the police authority.
And on the leading statement of this person, the body was recovered from the river bed. What more, my lord? And there was a previous enmity between them. That also came, my lord.
Okay, the incident took place, I think, October 2023.
My lord. One mobile phone of the victim or of the deceased was recovered from one person called Ashidul, which was handed over by this petitioner to Ashidul. Everything, I don't think that chain has been established. Recovery of paid, recovery of motorcycle, recovery of mobile phone. On his dating statement, the body was recovered from the river bed.
Okay, this person is Ramjan Ali.
Ramjan Ali.
Okay, now so far this Rashidul Reshmi is concerned. Rashidul Reshmi.
Rashidul was granted.
Then Rahul.
Because the conflict was issue between Rashmi and the deceased man.
Okay, the Reshmi granted bail.
Rashmi was granted, because she was not in the side.
Okay, then Rahul.
Rahul Haq granted bail on 15th of.
Rihajul and Narvanu.
Rihajul Haq granted bail. One Nurala Mia granted bail. All other. 1, 2, 3, 4, 5. 5 accused persons granted.
Here the main allegation is on the basis of this person's statement, the offending woman was recovered and the body was also recovered.
Body was
also recovered.
was also from the river.
Yes, but so far the 164 statement of the father of the victim is concerned, other accused persons are also named. Apart from this.
But because the main conflict was between the other accused persons, the lady, this Reshmana, with her mother. There was if my lord goes to the affair of the case of 164, it is written. Thereafter, this person, he actually murdered this person. He committed the offense. Others are 120 against them, 120 bail be there.
Other person.
Other person.
Yes, where is the postmortem report?
Page 184. Then the blood stain in the iron rod, which was recovered on the leading statement of this accused petitioner, that also, that will be listed. That will be, it takes.
All these things sent for appraisal, nothing was received by the appraisal authority, my lord. There is no, on this figure, there is no conclusion.
During the trial, it will be received.
There is no conclusion on this figure. All other on
182 postmortem report.
184.
184.
Regarding the trial, what happens, my lord? Once the case is filed, on the last occasion, they have not raised. The CD is with us. In the lower court, on the ground of CD, it could not be proceeded. Now again, they have filed this bill application, and it was fixed on 17th of November, just 3-4 days back.
No, the question is whether there will be any possibility to tamper the witness.
Why, my lord, statutory?
Total number of accused persons.
Why this type of cases, why there is statutory opinion, why they are taken into?
No, how many witnesses are there? Total number of witnesses?
30 is the thing. Maybe after 14, 15, if the prosecution thinks that already they have made out a case, they will not examine the other person.
Mr. Chakraborty, if you're in a position to tell us that we'll examine 14 witnesses, 16 witnesses, we can consider. But 30 witnesses, it's impossible to conclude the trial on an early date. Let's not be unrealistic. And come back tomorrow, tell us how many witnesses you propose. We are not saying that we will not grant bail or grant bail. We are saying nothing. But tell us that. Come back tomorrow. State,
The case under 602. The petitioner is custody about 208 days. Charge sheet submitted. Charge will not pay. Education is that, my lord?
yes, any eyewitness, Mr. Chakraborty?
The daughter of the
Hanging ante-mortem.
Page 49. Partially burned. Manually, listed seems to have used to sari or orna, madam. That is there in the sizzle.
Yes, what is the FIR?
Page sizzle is number 10.
Page number?
Cloth which was used, but only doubt is that that was partially burnt. So that is only the.
Page
doubt.
10, page 10.
Page 10, my lord.
So what material is there against him?
Here there was, and rest of the materials were torture, demands of those.
Torture demand.
Okay.
There is no 498A. It's only 302. Actually, the petitioner says that he is in custody for
208 days.
208 days. Stop. Charge sheet was filed on
5th of July 2024, 27th. 5th of July.
দেখেছো? July 15, 2024. Stop. Charge has not yet been framed. Stop. There is no incriminating material against him. Stop. How many witnesses? Charge sheet.
Last page of the.
11. Stop. There is no possibility of an early conclusion of the trial. Stop. He prays for bail. Paragraph. Opposing the prayer, Learned State Advocate draws our attention to the material in the case diary, including the postmortem report. Stop. Paragraph. On an overall assessment of the material on record and the possible extent of complicity of the petitioner in the alleged crime, we are of the view that further custodial detention of the petitioner is not necessary. Paragraph.
The defect to complaint lawyers, they have no objection. I am on behalf of the director.
Oh, you have no objection?
Actually, you see, it is a, no, question you see, it is a case of 302, okay? So your objection does not, but anyway, we'll record it. It is not a 498A case.
Learned Advocate for the de facto complainant, on instruction says that he does not oppose the application for bail. The usual condition, you want any particular condition? Huh? Right. 43?
44.
My lord, I am for the petitioner.
You said you
Can
will
your lordship
come?
hear me?
You said you will come?
No money, my lord. Market is very dull.
Everybody has fallen off the chair laughing.
No, my market is very dull. Without your lordship, market is dull.
Yes, tell us.
My lord, this is an application for bail. But is the state ready?
State? Yes. Yes.
My lord,
Yes.
it is a case under section 40A of the Foreigners Act. My lord, 5-2.
Yes.
Well, read that. But
52.
yes, my lord, 52.
Bad connectivity.
Yes, my lord, that's the worst part of it.
Yes.
my lord, read the order sheet, my lord. Rejecting the bail. My lord, starts from on perusal of the verification report.
There was a singular matter where it reached upcoming national matter. So my lord, actually for report. My lord,
No, what is the observation? Let us see. Note, the accused, however, managed to obtain PAN card. The genuineness of issuance of this is flawless.
My lord, lordship read it, my lord.
Yes.
Now, my lord, where the
Those
learned judge went
were
wrong.
already examined by the learned court below.
My lord, where the learned judge went wrong was, my lord, he spoke about having a Bangladeshi passport.
Yes.
My learned friend maybe for the state may produce the charge sheet, my lord. Just sees the charge sheet.
Bangladeshi passport and Afghan passport.
My lord, I'll tell you, lordship, but I'll come to that. Let it first show that there was a seizure of a Bangladeshi passport. Because
Yes.
on his statement, my lord, the
Seizure
court passed
list.
the order.
Yes, the list and the charge sheet. Is the list and the charge sheet.
Thou,
Now, my lord, see it. The documents which my lord Justice Chaudhary will see it, please.
my lord, page 5 seizure memo.
Page?
5 seizure memo.
Page 5.
Page 5.
My lord, see the charge sheet now. What has been seized?
No, where is the charge sheet?
Charge sheet is at the last page, my lord.
Last page.
Last page.
My lord Justice Chaudhary will see the list of documents seized on the left side, column number 11. No Bangladeshi passport.
nothing. Resident card of Oman.
Yes.
There's nothing is seized from him.
Now regarding PAN card and this
It's genuine. It's genuine.
Page 80.
voter IDs and all, page 80.
Page 80. Page 80, my lord, is the
Electric
172,
bill.
I have stated the voter card is genuine.
From 2013, my lord, electricity bill from 2013.
Everything is genuine. Ration card, electric connection, driving license.
Aditya again.
Very cheap. Very cheap. Issue. The petitioner is in custody for?
From 9th of June, my lord.
The petitioner says that
154 days. 154 days.
he is in custody for 154 days, stop. He is an Indian national, stop. He has been wrongly booked under Section 14, capital A of the Foreigners Act, stop. The learned trial court rejected his bail prayer in spite of finding that the state has, upon verification, found the relevant electric bill, voter card, ration card, electric connection, driving license, etc. to be genuine, stop. He prays for bail, paragraph. We have seen the order of the learned trial court. Stop. The learned judge rejected the bail prayer on the basis that the petitioner holds passport issued by the Republic of Bangladesh and Afghanistan, and also resident card of the Sultanate of Oman. Sultanate of Oman. Stop. However, comma, from the charge sheet and the Caesar memo, we do not find that any such passport or resident card was seized from this petitioner. Stop. On the contrary, comma, a number of documents showing the petitioner to be an Indian national have been found to be authentic documents. Stop. Paragraph. Therefore, comma, in spite of opposition from the end of the state, comma, we are inclined to allow bail to the petitioner, but on stringent conditions. Usual.
Grateful, man. Deeply obliged.
PD was received a moment ago.
Not today. Oh, no. Very bad, very bad. Not today.
I'm for the state first. That was filed on August and copies are on. That's why.
My 46, priority submission, 46 and today's list item number 54, arising out of same case number, two are separate.
After 46, we'll take a 54.
These are 300 cases. Charge sheet has been submitted against 8 accused persons. But out of 8 murder, 2 accused persons is absent on the murder. And murder, the allegation murder, kindly see my code. My name is murder, Warren Goa.
What is there against him?
There are several 164 statements named all the persons, named all the 8 persons.
Anybody granted bail till now?
No, not yet.
No.
Not.
So this is a test case.
Yes. I am custody about 161 days.
Charge sheet submitted on 21st of 2024. As the 2 accused persons still absconding.
Warrant.
Warrant already.
Yes, let us see.
After submitting charge sheet.
164.
Show us 160.
Copy after envelope. 176 onwards.
Any eyewitness?
But named all the persons.
No, eyewitness or not?
Yes, 176.
176 onwards.
The incident occurred at
all are in Hindi method. Named method, named.
one Ishno Gola one is a principal asset. Ishno Gola is a principal.
Charge sheet is in the last page.
Charge sheet is charge sheet page. Yes, last page.
Total 24 witnesses.
What was the incident?
Incident is that on the fateful night at about 1:30 AM. But allegation is that 8 persons all charge sheeted 8 persons had came to the house of the defector complainant and assaulted the son of the defector complainant. That is the allegation. And due to such assault, but the son had died.
Died on the spot or was taken to hospital?
Brought dead.
Brought dead to hospital. Any weapon recovered?
Not a
No.
bamboo stick.
Apart from this, this FIR maker, any other witness who are?
Just. Page 30, 32 and 120. 161 statement, 30.
30.
Yes, my lord.
Thirty, 32.
Yes, and 120.
So it is all Hindi.
Yes, all are in video, not all are named. All the 8 persons are named in 161 also and 164 also.
No, 30 is the statement of the local person.
Local person eyewitness.
1:30 AM eyewitness.
How the people witness the same?
PM report,
PM report is there, my lord. PM report, page 170.
multiple injury.
But offending weapon as bamboo stick, one rope and one called in Bengali lamsa.
Any
That is-
local persons made statement under 164.
No. Oh, my 164 statement, all are local people.
No, no.
176 onward, all are local.
167, 176.
176, 177 and 178. Fairly submitting,
Okay, 170.
all are named, all persons are named. But there is no specific.
No specific. No. 168 days,
Charge sheet submitted on 21st of August 2020.
20 witnesses, 30, 24. দিয়ে দিচ্ছি, দিয়ে দিচ্ছি।
24. Total witnesses 24, মানে 2 persons still are.
তো দেখবে ভাই। হ্যাঁ, বুঝো। The petitioner is one of 8 accused persons. Stop. He says that he is in custody for 161 days. Stop. 2 accused persons are still absconding. Stop. There is very little chance of the case being committed in the near future. Stop. There is no such evidence against him as would justify his continued detention in judicial custody. Stop. Paragraph. Opposing the bail prayer, learned state advocate draws our attention to statements of witnesses recorded under section 164 CRPC. Stop. Such statements as also the first information report name all 8 accused persons. Stop. There is nothing specific against this petitioner. Stop. Paragraph. We see that there are 24 witnesses named in the charge sheet. Stop. There is very little likelihood of the trial coming to an early conclusion. Stop. On an overall assessment of the material on record and the possible complicity of the petitioner in the alleged crime, as also keeping in mind that investigation is complete, we are of the view that further custodial detention of the petitioner may not be necessary. Accordingly, করে দিও, not to enter
Locality.
Nagrakatta police station. Nagrakatta police station.
Nagrakatta police station and report to local police station once every week. তাছাড়া usual যেগুলো আছে।
Not 54 and 55.
54 and 55.
We are in custody for 168 days. He was in custody for 161 days. We are in custody.
Otherwise, they are same.
All are same.
করে দিও same.
54,
54, 55.
Grateful. 50, 46 টা নিন।
State,
Lordship, a case of 302. I'm not entering into the merits of the case, Lordship. My previous rejection was on February 2024. Now I'm in custody for 503 days. Out of 25 witnesses, 13 yet to be examined. The de facto complaint and close witnesses have been examined. Circumstantial evidence, Lordship.
this is not a case where there has been no progress at all.
No.
A schedule has been fixed from 9th of December to 11th of December 2024 for taking examination of witness. Next date.
He is the 13th, you possibly
Yet to
won't
be
be able
examined.
to complete 13 witnesses.
There are almost 25 witnesses. They are remaining, my lord, and schedule has.
What is the material against him? Now that you have the depositions, have you gone through the depositions?
No, my lord.
How far they implicate him?
The case diary, my lord, doesn't, my lord, contains the, my lord, deposition, my lord.
You have the deposition.
collected the deposition.
Please give him a copy.
Lordship.
Consider, come back tomorrow.
Lordship.
Read it. How, to what extent the evidence implicates him.
My lord.
Lordship, I'll give it.
Murder,
I'll give it.
Lordship.
mandatory life. So we have to assess that.
Lordship.
My lordship.
Don't make us read the entire deposition. You will tell us.
Lordship.
I'll hand it.
Please.
I will. Lordship. 48.
Lord, I am for the petition in this matter. Lord,
302.
no, Lord. Lord, 498A and 304B. Lord, the corresponding sections of BNS were incorporated, Lord, 80 and 85 of the BNS.
Husband.
Lord, the thing is, Lord, the petitioner's wife, Lord, she was having a medical condition, Lord, called suicidal ideation, Lord, where they have a tendency to attempt to commit suicide. Now, my lord, in the last 5 years, my lord, this lady had attempted several times to commit suicide. But my lord, somehow, my lord, with the intervention of the family members, she was saved. My lord, this time what happened? My lord, she went out from the house saying that I am going to buy some things from the grocery shop. She took an e-rickshaw and my lord, she went, and in a nearby pond, my lord, it's in a secluded area, my lord, she goes down in the water. And my lord, due to drowning, my lord, the
PM says.
PM says so, my lord. PM says so. Lord, I'm in custody for 30 days now, my lord. And my lord, I have also annexed some documents.
The
My lord.
charge sheet is yet to be submitted.
Yes, my lord. Investigation is going on. Investigation is going on, my lord, but there is no specific, my lord, allegations directly against me, my lord.
Anyway, 164 statement recorded.
Only 161 of the neighbors.
161 of, this is the neighbor.
Neighbors, the neighbors are reported.
Yeah.
গোপালের আত্মীয় দাঁড়িয়েছে গোপালের দিকে ছুটিয়ে ইনভেস্টিগেশন it's premature, too early. We
Lord,
are,
may kindly see the postmortem report.
we
once.
have, no, that's all right. We have seen the statements. Investigation is going on. Charge sheet is yet to be submitted. We are not satisfied. What do you do? Issue.
Lord, not present. Grateful.
49. 49.
State. He?
Lordship, I'm praying for 1 day accommodation. Lordship.
51. 51.
I'm for the state.
I'm for the petition, Lordship. Lordship, the petitioners before your Lordship are the in-laws of the deceased. Charge sheet has been submitted, Lordship, under section 302. Two accused persons, including the son, that is Sayan Kabir, another absconding. I am in custody for 163 days. 90 days was the statutory period, but as because the charge sheet was submitted within the statutory period, my bail was rejected. Now, Lordship, the point I am raising it, the actual fact is, the son of the petitioner, Sayan Kabir,
Husband.
the husband, married twice. One is the deceased, another is another person. Regarding that, dispute cropped up between the two wives and the husband. One gardener and two flower. What happened, Lordship? Regarding this side, she consumed poison. From the FIR, Lordship will find that I have annexed the FIR, Lordship, page 11 of my petition. It is mentioned that পরিবারের অন্য সদস্যের প্ররোচনায় দ্বিতীয় বিয়ে করে is only allegation. But my main point is, Lordship, the charge sheet has been submitted. Positive evidence to file a charge sheet under 302. Lordship, kindly sees the PM report. If any homicidal death is stated or not, because my instruction is it was a suicidal case. But charge sheet was submitted under 302. Had it been a 304B, no issues. But 302 is definite allegation. Now, Lordship, the in-laws are behind the bar. Two accused persons are absconding. Lordship, retired employees. Senior citizen.
63, 61.
What is the material you have against these two persons?
Lordship, this is a case where within 7 years of the marriage, a lady was actually lady died due to administration of poisoning, and subsequently, and at that time she was pregnant. What happened actually is the petitioner present before your Lordship is no doubt is the father-in-law, but he is the one of the principal accused, because he allowed, he is a retired police officer. He allowed his son, who is a student of LLM, to ensure a second marriage and to ensure the entry of that second wife in the house. The first wife was administered poison, and And your lordship, no doubt he's a senior citizen, but he's a very influential person. He's a retired police officer. His wife is a retired government employee, and his another son, and his wife, both are now absconding, and they are relative. This is not the case that five different persons assemble and kill anyone.
Husband is the principal, husband is.
No, the father-in-law is the principal.
Husband is also in custody.
No, husband is absconding. And this is a very heinous offense, lordship.
Okay, let us see the
164. Yes, lordship.
How long you are in custody?
Lordship, I'm in custody for 163 days, 5 months, 10 days.
Yes, page
81, lordship. And what happened when this lady expired? His father lost the complaint, and when the body came to the house, the maternal house of the lady, at that time, after seeing her daughter that she is no more, the father expired. And so
For that, accused cannot be charged under 302.
For that, he has not been charged. For administering the poison, he has been charged.
Material has to be there.
Sufficient materials. Yes, postmortem report. Postmortem report is page 99. Death was due to the effect of poisoning, and the nature of poison will be identified only after getting the chemical report, chemical examination report.
But no homicidal or suicidal.
There is injury in the lip, over the lips.
She was alive, my lord. She was almost, my lord, subjected to torture and cruelty. Only on the reason, my lord, that, my lord, after she left, my lord, the house, the second marriage will be solemnized. That is the only reason, my lord. She was subjected to torture.
Marriage has already been solemnized.
No injury, no injury. What are you saying?
There is a statutory presumption also.
There is a statutory presumption.
Second proper, my lord, within 7
7 years.
304B, but 302 specific allegation investigation should be.
No, administering, she died due to poison. Whether that was administered or she took, that is the.
Lordship knows better than us that is the matter of the trial. That whether the poison was administered or whether she consumed the poison.
Absolutely right.
Absolutely.
Whether
That is the matter of the
yes,
at
now
this
what-
stage, lordship.
whether-
At this stage, lordship. This accused, no, lordship, I
You
understand.
have to satisfy us that custody trial is necessary.
Lordship, I am
Why?
telling custody trial, why pre-trial conviction is not permitted. That I know, lordship. But the important factor is the persons who are absconding, that they are also the son and daughter-in-law of this petitioner, and he's a retired police officer.
Yes.
Actually, he engineered the entire incident.
There was a separate court, lordship.
Yeah, there are 26 witnesses.
26 witnesses, lordship, and 2 absconding. So trial cannot be.
Here the
No
principal
direct evidence.
He is the principal.
No, lordship.
who perpetrated
Yes,
the
take down.
entire crime, my lord.
The father and son and perpetrated
Learned
the entire crime.
advocate for the petitioner and learned advocate for the state of West Bengal and learned advocate for the de facto complainant and program. Are learned advocates for the parties. It is the case of the petitioner that the petitioner number 1, who is the father-in-law of the victim, is aged about 63 years, and petitioner number 2, the mother of the victim, aged about 51 years, are not involved in the incident, but they are in custody for a period of, yes, how many days you are in custody?
Lordship, 163 days.
163 63 days. Learned advocate submits that the investigation is complete and declared for bail made by the petitioner. be considered. Learned advocate for state of West Bengal and learned advocate for de facto complainant objects the grant of bail. Learned advocate for the petitioner, the state of West Bengal submits that at the instigation of the petitioner number 1, his son contracted a second marriage, and he is the principal accused in this case. Stop. Upon perusal of the postmortem report and the materials of the case diary, it appears that the death was due to poisoning, but whether the poisoning was administered or it was a case of suicide cannot be decided at this stage. Upon further perusal of the materials in the case diary and the fact that in this particular case, the 26 witnesses are to be examined, there is no possibility for the trial to be completed within a short period. Thus, considering the age of the petitioner, we are of the view that as there is no reasonable apprehension to abscond or tamper with witness, the petitioner should be enlarged on bail.
Lordship, one indulgence.
Yes.
The petitioner should not enter the Moinaguri police station.
Yes, yes.
In the conclusion of
The
trial.
prayer for bail
Where do they stay?
made by the
They
petitioner.
don't,
Moinaguri,
Managuri, they'll stay outside.
outside.
Hence it is ordered, because a condition be given. The petitioners shall not enter into the jurisdiction of
Moinaguri police station.
police station. The petitioner number 1,
1 and 2.
no, petition number 1 shall meet the OC
Uh,
of Moinaguri police station
uh,
once in a week
uh.
and shall not meet the person acquainted with the facts of the case and shall not do any act prejudicial to trial.
Oh, শোনো, ওই not enter আর ওসি কে মিট করার তো contradictory হয়ে যাচ্ছে, accepting meeting the OC and attending trial. আর না 2 করবে না, খালি 1.
Much obliged.
My lord, 1 day accommodation, my lord.
1 day.
58, sorry, 56. 56. 57.
57, my lord. I had served, my lord, but there is.
But they did not record my attendance. I have already informed the members of Commissioner of Police actually.
No knowledge. I will say.
Now, can you see the paragraph number 3? Can you see the paragraph number 3 of my application? The Commissioner of
He says he responded to the 41A.
I have already stated to the Commissioner. See the
Tell us, what do we do today?
Well, the defecto is there, my lord. They are more, my lord, anxious regarding the rejection of the bail application. Regarding us, this is a case under section, a new act, section 89.
498A, 498A.
That is 498. Punishment 3 years. Section 85.
Charge sheet? He will, you're who? Husband?
husband.
There are 2 accused persons.
One got already privilege of anticipated level, and the husband went for here.
Yes, what do you have to say?
Lordship, the petitioner is threatening me to withdraw the case, Lordship, every time, Lordship. Last occasion, the bail was hearing, Lordship, last 9th of November, they threatening to the de facto complaint, Lordship. He is presenting court, Lordship.
The victim is being continuously threatened, my lord.
she's been continuously called by this husband, my lord, and my lord, saying slang words, my lord, over the phone, my lord. Lots of WhatsApp chats have been engaged, exchange between the husband and the wife, my lord. That is the reason why she's fearing if the husband is released on bail, my lord. If the husband is released not anticipatory bail, my lord, she will be, my lord. Yes, my lord. Again, subject to
He is already at large.
Yes, my lord.
He is not behind bars. So he can do whatever if he wants to do something foul.
No, they are deciding separately. At present.
There is no injury, only mental torture. We did not provide.
Some restriction has, anyway, some restriction condition will be issued. The de facto complaint is residing at her paternal house. Okay. So petitioner will not go there, shall not.
That police station he will not enter. Is it the same police station? No.
Police station is. Bhakti-Nagar, and she is residing also. I may be permitted not to enter to jurisdiction of Bhakti-Nagar.
You will not enter Bhakti-Nagar.
I will come.
Issue. Read order dated November 5, 2024. Paragraph. The petitioner says that in terms of the said order, he reported to the concerned police station, stop. However, his attendance was not recorded, stop. He has made a complaint to the Commissioner, Siliguri Metropolitan Police, stop. Let a copy of the complaint dated November 7, 2024 be kept with the records. Paragraph. The allegation is under section 85 of BNS. It is the BNS Act, no, BNS. BNS Act can লিখছো তোমরা। Particular corresponding to section 498 capital A IPC, bracket close. So, we have considered the material in the case diary, stop. On an assessment of the material on record, we are of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer fully, stop. Condition গুলো দিয়ে দেবে, তারপর আরেকটা তারপরে লিখবে, ওর ভেতরে দেবে, he will not enter the jurisdiction of Bhakti-Nagar police station, stop. He will not in any manner intimidate or harass the de facto complainant, stop. Has the de facto complainant made any written complaint to you that he is being called, he is being harassed, she is being harassed?
Yes, Lordship.
What is?
Before the police station, Lordship.
Stop. In case the de facto complainant lodges a complaint in this regard with the jurisdictional police, the police will immediately look into the matter. Look into the matter. So.
Praying for 1 day acceleration.
Yes.
76. 76. 77.
Actually, the case diary is not here.
Next.
78.
Not today.
80. 81.
Then all other matters shall be.
What matter is there? 94.
CD is available in which
CD is
matter?
available, 94. No, no. All books get a 100.
আচ্ছা তো কোর্ট ডাকতে থাকো ডাকতে
84. 85.
86, 87, 88, 89, 90, 91, 92, 93, 93,
One by one. All justice.
94.
I'm for the state, my lord.
I'm for the pressure.
The allegations are under section.
94, you're there. Yes.
The allegations are under section 498 and 307. Charge sheet has already been submitted, your lordship, on 31st/12/2023.
You are the husband.
I'm the husband.
No medical malad, no injury report. 300.
The petitioner is the end of the de facto complaint. Stop. The charge is under sections 498 capital A oblique 307 IPC. Stop. The petitioner says that investigation is complete. Stop. Charge sheet has been filed. Stop. He says that he has been falsely implicated. Stop. He prays for anticipatory bail. Paragraph opposing the prayer, comma, learned state counsel draws our attention to the material in the case diary. Stop.
Lordship, the similar matter, item number 74 is 75. That is the mother-in-law.
Let us complete this matter. Material in the case diary. Stop. We have seen the medical report. Stop. The same does not.
There is no medical report.
There is no. Oh, there. Stop. We have seen Kirada. There is no medical report available in the case diary. Stop. There's nothing to corroborate that the de facto complainant ever sustained any injury. Stop. Paragraph on an overall assessment of the material on record and considering that charge sheet has already been submitted, comma, we are of the opinion that immediate custodial interrogation of the petitioner may not be necessary. It's 70, it's a and another one you said?
Mother-in-law.
Mother-in-law, same, Shono. 75 ta. The petitioner is the mother-in-law of the de facto complainant. Kore, bakita, motamoti same. And what is her age? Mother-in-law's age? Shono. Rector, and also considering that she is a lady, the petitioner is a lady. And aged about 57 years. Immediate custody and not test. Next.
Item number 95.
You tell us what should we do?
Which section? Yes. Okay, charge sheet is submitted. And
354 and 350, those are the principal.
the charge sheet submitted under which section?
All the sections, all the 315 as in the charge sheet, it has been stated that 315 is not accepted in respect of the these petitioners before.
Okay.
And one principal accused who has already granted bail, where in the 164 statement of the victim lady was taken into the consideration.
Yes. Yes.
Is engaged in courtroom number 3, my lord. Follow later.
No, tomorrow you see if CD is not available or whatever, CD has come.
Yes.
Anyway, otherwise the
Short passover I take within 5 minutes. If I can get the CD, I'll do it, my lord.
okay. So next day you see we have to consider the charge sheet and then
call the next one.
Pass orders.
97. 98. 98.
Yes. কত নম্বর ভাই? 98.
Many accused parties, physical accused in custody, my lord. It will be, my lord, 326, 307 earlier.
Okay.
It's murder and previous, this is the main charge, my lord. And I feel that I am not present at the place of offense.
You were not present.
Yes, what are the allegations against him?
FIR named.
He was present, statements of eyewitnesses are there. 1, 2, 3, 4, 5, 6. 6 eyewitnesses who have seen the accused person, including this petitioner, who assaulted.
By name, he is
By
named.
name.
Okay, which page? 164?
Lordship, kindly says from page 11, 11, 12, 13, 14, 15, 16.
11 is 161.
161.
No, 164.
164 is not there.
Okay, where is the injury report?
Injury report. Lordship, injury report, there are various injury reports. Page 63 is one.
Out, anticipatory.
Then page 28 to 60, 63 through 84, page 100 to 107, all medical documents.
Anything serious?
Page 63 injury report, that says it's grievous.
It is grievous.
And page 99 is the injury report. One is grievous and another is laceration.
Grievous injury.
Grievous injury.
They have accused her on custody.
No, Lordship, this is anticipatory.
No, I'm telling whether the other accused persons
Other
are on
accused persons.
bail or in
You
custody.
can say. All are principal accused. This is the 161 of the eyewitnesses.
Okay, that is page
Page
11.
It starts from page 11. When Shopon Singh was arrested,
Aravind Singh এর নাম আছে? অপু, ডাকনাম অপু।
yes, Lordship. 6 eyewitnesses.
Yes, your name is also there in the statements. It's not that you are not involved. Is all the statements, his name is
Yes,
mentioned.
Lordship. They named all the SLNs.
The allegation is of attempted murder and grievous injury and causing grievous bodily harm. Stop. The petitioner says that there are several accused persons. Stop. He was not present at the place of occurrence. Stop. Charge sheet.
No, Lordship, it is going on.
Stop. He has been falsely implicated. He prays for anticipatory bail. Paragraph. Learned State Counsel draws our attention to the material in the case diary. Stop. We have seen statements of witnesses, statements of at least 6 witnesses recorded under section 161 CRPC. Stop. Each of the witnesses has named this petitioner as one of the assailants. Stop. We have seen the medical reports. Stop. More than one victim? No, one.
One victim, Lordship.
One victim. The victim suffered grievous injury as per the medical report. Stop. Paragraph. On an overall assessment of the material on record and the nature and gravity of the alleged offense, as also the possible complicity of the petitioner in the alleged offense, comma, we are not inclined to allow the petitioner's prayer for anticipatory bail. Dismissed.
Declare, Lordship. You can give the city.
100, 100, 101, 102, 103. 103 million. This is the fourth operation.
Let the IOB called for alert regarding this matter because we have sent the intimation.
Oh, the CD is not available.
Which sections? Yes.
Under section, my lord.
This is the fourth occasion
Charge sheet
when
submitted.
adjournment is sought for on behalf of the state. Since the relevant case diary is not available, paragraph, let the concerned investigating officer be present in court with the case diary on Wednesday. Wednesday date দাও, paragraph, learned state advocate shall immediately communicate this order to the concerned investigating officer. List the matter Wednesday করে দাও। আমাদের নামের উপরে দিয়ে দেবে।
Item number 104, 105, 106, 107, 108. 108 million. I for the petition. The charge sheet already 5 million. 108. Allegation under law 341, 323, 326, 307, 503, 34 of the.
Yes, charge sheet is submitted. 326. Yes, where are the
grievous charge sheet submitted.
no, where are the allegations against this person? Which statement?
All three accused petitioners assaulted the victim.
Where? Which page?
Victim statement, page 30.
Page?
30, 30.
Any independent eyewitness?
No, Lord.
30.
Medical?
Medical page, Lordship 28. Injury report.
Injuries. Injury নাম করেছে, দেখে নিন। আচ্ছা। Crime assessment. আপনার হচ্ছে crime। আর আছে তোমার সোলেমন আছে, অনিরুদ্ধ আছে।
Yes, injury report, which page?
Page 28.
In support of what proposition? Then what?
Anyways,
Can be. Who said can't be?
it is not an indefensible right. You say. Yes, against this thing, petitioner number 2, there is allegation.
He was the prime assailant.
So charge sheet is submitted.
Charge sheet is submitted.
Two we are rejecting, 1 and 3 we are granting. Hey, Esho. They are the only 3 accused persons. The allegations against the petitioners are of attempted murder and causing grievous bodily harm. Stop. The petitioners say that investigation is complete. Stop. Charge sheet has been submitted. Stop. They may be granted anticipatory bail. Stop. In any event, comma, they have been falsely implicated. Stop. Paragraph. Opposing the prayer, learned state counsel draws our attention to the victim's statement recorded under 161 CRPC. Stop. He vividly describes the alleged incident and names all the three petitioners. Stop. However, from his statement, it appears that the petitioner number 2 was the prime assailant who inflicted injury on the body of the victim with a DAW, inverted comma. Stop. The injury, the medical report says that the injury was grievous. Stop. Paragraph, considering that the petition number 2 appears to be the prime assailant, we are not inclined to allow his prayer for pre-arrest bail. Paragraph, insofar as the other 2 petitioners are concerned, on an overall assessment of the material on record and considering that charge sheet has been submitted upon completion of investigation, we are inclined to allow their prayer. Next, accordingly, this application is dismissed insofar as the petition number 2 is concerned. Paragraph, insofar as the petition numbers 1 and 3 সব নাম দিয়ে দেবে কিন্তু সবার, are concerned, in the event of arrest বলে। And 9. CD is there. Not today. Come back tomorrow. They will be serially as they are listed today.
যতটি হলো আর কি, যতটি হলো তারপর থেকে কালকে 3:30 থেকে সিভিল নেওয়া যায়, 3:30 করে দিলে
One hundred and 10, 11, 12, 13, 14. No, I'm single. 15, 16, 117, 118, 119, 120, 121. Yes.
Section 341, 326, 307, 506 for the Indian penal. There are several cases and counter cases. The long-standing dispute between both the family members of the petitioners and the fact of government. And it's some of
How anticipatory?
গুলো আছে বাবা, 8 জন মামলা করেছে। 8 petitioners.
Nature of injury, Mr. Ganguly?
Yes.
Very serious.
Okay, let us see the statement against this petitioner. One person is on bail or anticipatory bail? Jatindra Rokshit.
No.
No, what is this? Allowed stated. Allowed for the
bail.
Okay.
Bail. It will reach it.
Bail. Oh, yes, please give us the.
This is statement of the witness.
Eyewitness.
Names. Most of the case studies,
Jyotinder Rokit has been granted bail.
Jyotim Rohi, yes, he is not here.
Vishwanath Sarkar, Joydeep Sarkar. Joydeep Rokit.
Yes, what is the statement of the victim? And the injury?
Victim and the injury.
Injury report, Lordship, page 28 to 39, 71, then 59 to 71.
Okay, you give the victim.
Bulk of injury. Just see the photographs and it will be clear. Mercilessly beaten.
Yes, victim statement. And any recovery of weapons from any?
Lordship, this is anticipatory bail.
No, no, from the
without
other,
apprehending
no, from the other co-accused?
No, Lordship. Actually, most of the case that is full of this medical, and this is the victim.
Just for your information, today for some administrative work, we'll rise early. About 3:45. এরা এসে পরে জয়েন করে রাখো যা করবে পরিবার
Your charge sheet is submitted.
Yes, Lordship, page 81.
Kindly clarify. The petitioner took some illicit photo of the PG.
No, which case are you saying?
Lordship, he is a defecto.
No, defecto.
The incident occurred due to what he is saying now. There was a previous case. where the photographs were viral, and then this citizen happened.
Oh, this is a retaliation.
Lordship, in FIR, there is a mention of another case that is 17/24, dated 11/1/2024, 341, 323, 325, 307, 506, 34, out of which this is the second case.
Okay, that is a counter case.
No, lodged by this party.
The allegation, they have lost one FIR earlier
Yes.
regarding some photograph, but
Yes.
they have not mentioned what kind of photograph. But in the sections of the lordship can check, there is no section of what.
Oh, against the same accused persons, all this.
Same manner, there are 7 cases, I have, and I have stated in my para 7 manner, see, there are other cases also, there are cases and counter cases dispute.
After lodgement of that FIR, this case happened.
Case counter.
They have lost the FIR against the same set of accused
Same
persons.
day.
Then-
And why they have lost? In retaliation, they have once again mercilessly assaulted, and this is the second case happened.
But on the same date, earlier.
Okay, where the,
No manner, but January when they have lost the FIR, on the same day, the petitioners have also lost the FIR. Same day, in 11 January 2024. There are 7 cases.
okay,
of-
one accused is on bail and the charge sheet is submitted. This is the position. Yes, please take down. Learned advocate for the petitioner and learned advocate for the respondent, State of West Bengal, and learned advocate for the de facto complainant are present. Are learned advocates for the parties and produce the materials in the case diary. Learned advocate for the petitioner submits that the investigation of the case is complete and there are case and counter cases between the de facto complainant and the petitioners. Learned advocate for the respondent, State of West Bengal, and learned advocate for the de facto complainant objects the grant of bail. Upon perusal of the materials in the case diary and considering the fact that the investigation of the case is complete and one who accused person is on bail, this court is of the view that in the interest of justice, petitioner number 2, 3, 4, 5, 6, 7, and 8 should be granted an anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioner number 2, 3, 4, 5, 6, 7, and 8 made by the petitioner. The conditions, the petitioners upon being released on bail shall meet the officer in charge. Yes, which police station?
This is Wanagudi.
Moinagudi police station. And shall not enter into the locality where the de facto complainant and the victim resides and shall not meet the persons acquainted with the facts of the case and shall not do any act prejudicial to trial. With regard to prayer for anticipatory bail made by petitioner number 1, the Nipen Rokshi, the same stands rejected.
Deeply obliged.
Since it appears from the material record.
We take it with the but potential. Will be civil time.
Civil matters, item number 230. What? Item number 231. 232.
Lordship, 32, I have Lordship. Lordship.
Yes.
Item number 32, Lordship.
Item?
Lord, I appear on behalf of the appellant applicants, my lord.
Your application?
Is my application, my lord, my application for restoration of 2 CAN applications dismissed in default.
Appeal is pending.
Appeal is pending. Appeal is pending. The applications are one for injunction against the original defendants, and the other was injunction against the added defendants who are transferees pendent till IT. Now, my lord, both these applications came up before the Honorable Division Bench, dismissed for default.
Very good. Can 5.
5 है तो.
Let's give the service side.
My lord, I appear for the respondents. My lord.
Yes, Mr. Dashmukto, you know our view. Restoration application, don't even try to oppose. We are allowing. Affidavit of service filed in court today, we kept with the records. Paragraph, this is an application for restoration of CAN 1 of 2023 and CAN 3 of 2023, which were dismissed for default on September 26, 2024. Paragraph, having heard the counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the applicant on the day the 2 applications were dismissed for default. Paragraph, accordingly, the order dated September 26, 2024, please recall CAN 1 of 2023 and CAN 3 of 2023 are restored to their original files and numbers. Paragraph, CAN 5 of 2024 is disposed of. Paragraph, this CAN 1 and CAN 3 before the next circuit.
I was representing one of the, my lord, parties who was added in this proceeding.
Give your name, give your appearance. Both are restored.
Oblige, Lordship.
Two 34, 235, 236.
Where's your other side?
230, 236, I am for the appellant.
Appellant?
Yes, both.
Lord, my lord, my junior is there here. My lord,
Possible. Huh?
Oh, it is condonation of delay matter.
there one can application, my lord, there is some delay, and another, my lord, application for appropriate order. My lord, my petition has been dismissed.
Have the delay application. Huh? State is not there. No, she is not. How much delay? How much?
According to my lord, 89.
Who have you served? Oof, state. Government pleader's office. Mr. Chaudhary, what should we do? Service has been effected on GP's office. The delay we'll condone. Delay we condone. Main matter we'll keep.
I'll keep it tomorrow. I'll let me check it.
Very well. There's 90 days.
Otherwise,
delay.
please stay.
Very well. Tomorrow to be mentioned in the at the beginning.
In any event, tomorrow your lordships are taking the civil matters past.
This is what we are thinking. We don't know because majority of the learned lawyers, they want criminal.
You want to pay T20 max.
T20 max.
Oh, if it is merely
what we can do, Mr. Chaudhary, we can take civil, we can start with civil up to 12 o'clock.
2 p.m. till 2. You see, in the mean, exhausted. 2 means I mean 1. I mean, if it is exhausted, The entire half day can be.
Because the pendency is definitely.
So
much
there is
more
only
than
2 more
the-
days effective.
Lordship,
Up to
so many
12.
matters.
Also, the
Up to
criminal
12.
matters also
Yes.
should be.
We'll take
given
it up to
priority.
12, civil matter, and then, so this matter will be tomorrow
At 12. At the
at the first.
My lord, may I request your lordships, my lord, the section 5 can be condoned, my lord, the
Tomorrow, Mr. Advocate General wants to take some instruction.
Because some, the lawyers should be represented from the states. That is the reason
ठीक है.
who is representing.
let him seek instructions, my lord, on the main matter, my lord, the only section 5 application.
237, 238 and 239. Well, your lordship already gone through the judgment copy. Learned counsel today have personal difference. They had to lay parley to the.
Which matter is this?
That appeal against the single judge order in RPF.
RPF.
Oh.
Kindly not today.
First-
I have no objection, my lord.
personal
I don't
ground.
think my lord will be able to take it up tomorrow also.
Whatever happens will happen.
No, my lord, I am not objecting to the prayer made on.
Let it just be not today and we'll see tomorrow.
I am not objecting. Personal ground.
240, 241.
I am appealing for the appellant writ petitioner. But this is a matter relating to the compassionate appointment.
Have you served?
Yes, but state respondent, they have already appeared in the earlier occasion, you lost it directed to serve to the university. I have served and it is an effective service.
Very well, but today nobody is there. Mr. Chaudhary, kindly also look into this matter. Nobody is appearing. 242. Hey, Shuru. What's up? No, not here.
243.
For the Kranti GP, but state is not.
My lord, on the last occasion on 6th of November, your lordship was pleased to direct the appellant to cause press service upon the Pradhan and his learned advocate. There's a pending earlier order.
Report has to be
Yes, my
filed.
lord. We have complied with the lordship's order.
You're appearing.
On
Where-
earlier occasion, there was one delay due to traffic jam.
Report is there.
A prima facie report is there.
What do you mean prima facie report?
We find that the documents filed by the petitioner, that is also defective. And we need some more time. What are the report?
Order to the.
The file.
Lordship, on behalf of the private respondent, I am praying for 1 day accommodation, Lordship.
Bojo.
Mr. Ghosh will appear in this matter. He left the court for his personal urgency, Lordship. Tomorrow, Lordship.
Because there was a specific direction to. present.
Accommodation is prayed for on behalf of the private respondent. Paragraph, as requested, comma, let this matter stand adjourned for the day.
44.
I am going to appeal to this matter. It is the union that is opposing me. The matter pertains to the successful Sima Bal.
Who is appearing for the union? Tomorrow.
Specifically fix it at 2 tomorrow. Unless may kindly fix it at 11 or so. This is an old matter, it needs to be
11 PM.
11 PM fix. I am so grateful. Deeply.
11 PM বলেছি তো। Call the next matter. No fixing, no fixing. Come on.
45.
It will retain its position.
Yes, retain its position.
45.
In this matter, I am appealing for the appellant.
For?
Appellant.
Appellant.
The state appellant. my lord.
Yes.
73 as filed up.
For the respondents?
I'm for the respondent number 1.
Respondent. Yes,
Before my learned friend puts the appeal into motion, I have a query. Number 1, Let me begin my case. No. Because on the first day, on 4th, it was submitted on behalf of the appellant that there are some defects in the appeal. So they wanted an accommodation. Accordingly, the matter was fixed on Monday. Now, the copy which was served to us was served prior to 4th. So I just wanted to know what defects were there and whether I have been served with a corrected copy or not, number one.
Yes, Mr. Chaudhary, what was the defect?
Look, there was a defect only with regards to a pagination. That with the leave of the Milord, the
Yes, I remember. Doesn't affect the merits of the case at all.
Okay. Another thing is, I'm respondent number one. Now there are 11 more respondents.
Private respondents?
Yes, not state respondents. So I don't know.
state respondent.
No. Just come to the cause title of this. Now the appellant is State of West Bengal and Director General of and Inspector General of
All are
Police.
Milord the pro forma respondent.
One minute. Let me complete it.
Not complete.
Now, I am the respondent number one. Now come from number 2 to number 12. Just come down, respondents. I just want to know whether affidavit of service on this respondents has been filed before this honorable court.
So, but how are you concerned, sir? These are all officers of the government. They are really pro forma respondents,
Then
perhaps.
they should have been made pro forma respondent. Then,
Yes, this is a technical thing. They are in substance pro forma.
yeah, 5
You-
years
you-
now. Enough experience we have.
You are
should
the
not-
you are the answering respondent. Now let us see what the case is about.
Milord. The impugned order, Milord.
Yes, let us see the impugned order.
Yes, first, Milord. That is, Milord, 30th September 2024, Milord. But Lordship got it.
Yes.
Lordship, kindly see the paragraph 2 first.
We will just hurriedly go through this.
Yes.
Yes.
I am agreed with regards to the paragraph 8. Paragraph 8 say, be that as it may, let report of the Commissioner, Jalpaiguri Police Commissioner be filed before this court, disclosing compliance with the direction by the Honorable Division Bench.
Yes.
And the paragraph 9 is with regards to the district judge. Now, Milord, kindly see the paragraph 2 first. This direction was passed pertains to our Milord, the writ appeal, that is Milord, MAT 26. Paragraph 2, Milord, it is said categorically. Milord, in the said writ petition, the separate affair which was challenged by your writ petition should be quashed in a separate affair. In the said, the trial judge did not interfere with that. Matter went in an appeal. Then there was a direction from the Honorable Division Bench that disciplinary proceeding or the other things because 41A has not been complied with. Now, my lord, in that order, we have preferred a review application because prior facie apparently, my lord, there is an error because, my lord, there was a section which discloses the cognizable offences, punishment more than 10 years. So 41A notice is not required, my lord. In that score, we have challenged, we have reviewed the, we have intends to review the application, the order, my lord, which is still pending before the Honorable Division. Number 1, my lord. Now, in this writ petition, my lord, there is a separate FIS. There are 6 or 7, my lord, FIS which they have challenged. Not pertains to the FIR which has been decided by the another matter pertains to a 26, 23, my lord. So, my lord, the writ court was not in the season of an executing court. Neither, my lord, there was a content even, such direction cannot be given. Now, my lord, kindly see what was the contents of the said writ petition. My lord, in the my lord, can application, can 1, my lord. The writ petition, my lord, has been annexed.
This is the earlier writ petition, present writ petition. It's page 33, possibly it starts. 1944 of 24.
Yes, my lord, 30 points. Prayer. My lord, kindly come straight to the prayer. Straight to the Lord, kindly come to the prayer. This belongs in 52 belongs.
59. Prayer?
Prayer belongs in the writ petition.
Yes, page 59.
But it's not a prayer, about the
Page 59, 60.
yes. Before that, Lord, kindly come paragraph 11. Sorry, Lord, I will come little later that prayers. Paragraph 11. Page 50. 2 below.
Yes.
Paragraph 11. What is the contention of the writ petition? Contention was that serial number from 1 to 6, 7. This 7 affair was initiated against the writ petition. Paragraph 11.
Who is the writ petitioner? Very well. Yes.
So all these affair, Milord, registered in the said Bhaktinagar PS case, Milord. Now, with regards to Milord, 1, 2, 3, 4, 5, 6, 7, Milord. Already which he has disclosed, Milord, kindly see the serial number 1, which he said that pending. But our record is that charge sheet is filed. That way I will demonstrate from their writ petition even. Then, Milord, 2 said FRT is filed.
Civil nature.
Yeah, because of civil nature, FRT is filed.
Same with 3.
Same with 3. The Milord, kindly come same with 4.
Yes.
Same with 5. FRT for second line, Nobendu. Serial number 5.
No, 4 is pending because
No,
of a
Milord.
stay order.
No, Milord. Paragraph 4, serial number 4, second line.
Yes,
Continue.
FRT being number such and such.
Criminal revision, there is a stay.
No, Milord. There was a stay. Ultimately, it has been ended with FRT.
Oh.
Ended with FRT.
Very good. The criminal revision was
Ultimately, Milord, it was not, I think it not been succeeded or something.
not succeeded.
But ultimately, the FRT has been filed.
Very well.
5 is same FRT has been filed. 6, Milord, what they said, suit was decreed in favor of, it is silent. But here the charge sheet filed. In serial number 6, charge sheet filed. Serial number 1, charge sheet filed. Serial number 7, Milord, again the FRT has been filed. So out of this this challenge by your 7 consecutive affairs, these 5 has already been decided. So they cannot challenge it, number 1. Now kindly come to the prayer. Yes. 59. So, my lord, what they have claimed? Mandamus
That
directing.
means they are seeking to recall that effort and reinvestigate.
But I do not know, my lord. That possibly, my lord. Then we are very happy to do that.
No, but these FIRs are against the writ petitioner, no?
Yes. Yes. So this is the reason, my lord, the way of writ petition, which the affair has been ended with the FRT or FR, my lord. Only out of the 7, 2 is alive.
Right.
Which the charge sheet is filed, trial to be commenced, or what trial is in progress, whatever, in nature. So writ petition filed, which my lordship is correct. I was a little bit confused in the initial stage, what they're asking for. Now, what they say, that the said affairs, kindly see the writ of nature, manner, directing, respond each other to forbear from giving effect or further effect, recall, set aside, and was the criminal proceeding. So it is not an existence now. What quashing of criminal proceeding is not an existence. Then paragraph, then at the end, pending before the Chief Judicial Magistrate Jalpaiguri, the prayer A, 2nd page, pending. So it means, Milord, it is not even a pending. Only 2 cases are not even pending for a trial. Now this was the situation, Milord, here.
2 cases are pending for
Pending,
trial.
which they have challenged.
No,
that
two cases charge sheet submitted.
each charge sheet submitted, trial to be commenced.
Yes.
So they have challenged the 7 affair to be recalled, set aside, or whatever.
In one writ petition.
In one writ petition. Now, Milord, what is the order in the said, Milord, MAT 2623? Milord, I will just read because it has not been 2623, because pursuant to that trial, and the trial just said compliance to be made by the commissioner for disciplinary action, termination, whatever, and the district judge for consequent there. This is the order, Milord. I just hand over the order of that in the said Milord appeal. May I hand over? That is the MAT 26, which Milord Lordship has reflected. Lordship got it, Milord?
Yes, 1 second.
Yes. Milord, the first line said, the order passed by the learned judge in WPA 1018, separate writ petition. It is clear?
1 second.
Milord.
Yes.
Milord, paragraph 1. That is the appeal against the order in WPA 1018/2022. So
Yes.
definitely, Milord, in the another writ petition, the order was passed. What are the challenge in this writ petition? Milord, kindly see. Paragraph 2 say, the brief facts that the Bhaktinagar police station received a complaint 4th May registered affair under section 447 and the other sections. Milord, now kindly come page 3, internal page 3. Lordship got it, internal page 3?
Yes.
It has been the quote unquote portion, Milord. It has been reproduced. What is this? In the court of Chief Judicial Magistrate through GRO, kindly mark Bhaktinagar PS case number 450 of 2022, dated 4/5/2022, section such and such. So, Milord, this is the case. Part writ petition was challenged, pertains to an affair of 4/50/2022. Now, my lord, kindly correlate that from serial number 1 to 7, which they have challenged, not 4/50 of 2020. But the order passed in that writ petition pertains to an affair of a 4/50/2022, because non-compliance of 441A, police should take steps, magistrate should take steps for such removal from their office. That was the order. We went and reviewed. Now, my lord, in the writ code, there was a separate challenge by of this writ petition, that the 7 separate affairs. Out of that which I have placed, 5 is non-existence. In that order, the learned trial just said The order passed by the Honorable Division Bench, compliance to be made by the Police Commissioner. It's completely perverse, my lord. Number one, my lord, this is not a challenge before the learned trial judge. Not even decided by the learned trial judge. It is a matter pertains to another writ petition, another affair, which went in an appeal, matter still pending for review. So this is, my lord, giving me a trouble with regards to paragraph 8, my lord, for compliance, my lord. We don't have any problem for filing a compliance. But which is the order is non-aged. The matter is subject matter is totally different. How the writ court, I'm asking myself with respect, can direct me with regards to another order passed by another division bench? He is not sitting in a division bench. In that score only, my lord, at this juncture, my lord, my challenge is that suppose now even in the writ petition, which the 7 affairs which he has challenged, asking for recalling the order or the setting aside, that I do not know what is the prayer. If the 5 is recalled, that further investigation to be made, we are ready to do. With regards to 2, charge sheet is filed, pending for trial, that to be adjudicated.
Each petitioner was the accused in those FIRs.
5, sorry, 7.
Yes, 7 FIRs, the writ petitioner is an accused.
Yes, my lord.
Now the question is if it is an FRT, okay. Whether, so how is the writ petitioner prejudiced? If it is an FRT.
That is my question, my lord. That is my question. Initially I thought that your lordship rightly said
it is not the defect. It is not the de facto complainant who has come.
It's not. And even that is to separate, that would be adjudicated by the writ court, which is pending before the learned trial judge, my lord, at this moment. But here the order which has been passed in a separate writ
The writ petition is pending.
This writ petition is pending, my lord, only for compliance. My lord, without that compliance, what compliance you will give? Compliance with regards to the other writ petition, other affair, that to be filed by the Honorable Division Bench, which is the season of the matter.
So earlier there was no direction for compliance by the writ court.
No, my lord, in that
by the division bench only.
Division bench, not division bench said you do this. This is the division bench order which I have, my lord.
Yes, yes. Appeal was disposed of.
Appeal disposed of. Appeal disposed of. This is the order passed by the Honorable Division Bench with regards to the another affair.
So if there is non-compliance with that, any aggrieved party can go before that division bench with a contempt application.
Contempt application. And we preferred in a review, just because it is the error apparent from face of the record, my lord. My lord, kindly see what was the direction in the said which I have handed over to your lordships. That was the order with regards to a forfeit. My lord, kindly come. Page 8, paragraph 19. Which the order which I have passed.
Yes, seen.
Insofar the investigating officer they said Bhakti FIR number 450. 4th May 22. In terms of para 11 said Anesh Kumar.
But 450 is not subject matter of the present writ petition at all. This is the short point.
Very short point.
Totally beyond the scope of the writ petition. Sir?
With due respect to what my lord friend has said, he has projected one side of the story. Why this order was passed and this order of 30th September is a recent one, if we have to look into that and adjudicate it properly, in proper perspective, we have to look into the ancestry record and the lineage why this order was passed. For that, I humbly submit that in order to deal with the order impugned dated 30th September 2024, of course, as per the appellants, to me, it's not an order impugned. Passed by Your Ladyship Honorable Justice Amrita Sinha in WPA 1944 of 2024, being the subject matter of this instant appeal, a bird's eye view on the cause as to why the order was passed. That is, to look into its recorded ancestry or lineage is to be looked into first for proper adjudication.
Sir, just please satisfy us on one small issue.
Yes.
The earlier writ proceeding.
Yes.
Which was carried to before the division bench.
Yes.
By way of Mat 26 of 2023.
Yes.
That pertained to a particular.
Yes.
Case.
Yes.
that pertain to FIR number 450 of 2022.
Yes.
In connection with that FIR, the division bench passed certain orders.
Yes.
It is not for us to say whether the order is good or bad. We are a coordinate bench.
I'm not.
The aggrieved party has filed a review.
Right.
The review will either succeed or fail. The present writ petition does not concern FIR 450.
Got
If
it.
that be so, was it not beyond the scope of the writ petition for the learned judge to pass an order for complying with the division bench order, which was passed in connection with an FIR which was not before the learned single judge?
This is not the story. That is why.
No, we have to go by the record. We don't know what is the story.
If we have to go by the record,
Yes.
that is why it is my humble submission that we have to look into the ancestry record and lineage of the total case. Because in that case, both the writ petitions were filed by the petitioner against police atrocities. In 1944, that is the second writ petition. In 450, all the 7 cases were put into by a supplementary affidavit. Kindly come to that order. What my learned friend has submitted before. না 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 আমি তোমারটা নিচ্ছি না রে বাবা Now come to para 21 of that order. Insofar as the subsequent FIR registered against the petitioners are concerned, any grievances there against may be agitated in an independent proceeding, because in that writ petition, by way of a supplementary affidavit, all these matters were reflected before the court. But the single judge's bench in the writ court, it was only decided on 450. That is why the division bench has given me the liberty to file separate cases if there are any grievances in a separate proceeding. Accordingly, this new 1944 writ petition has been filed. Now, 450 was against police atrocity. 1944 is also against police atrocity. In a bailable case, I was taken into police custody. I was for more than 2 days, and in a bailable case against me, remand was sought by the police authorities.
Anyway, that was considered by the Honorable Division Bench in the earlier appeal.
No. This is the case, the new one, 1944.
No.
Now, in the earlier one, on 10/8/22, an order was passed by His Lordship Honorable Justice Ravi Kishan Kapoor.
Sir, please.
Directing, one minute, directing this respondent number 3 to file a report. For 2 years, the police authorities, they haven't filed a report before the honorable court. And the order was passed on thereafter, after 2 years. So taking into consideration that point, the division bench has taken that stern decision. Now, when this picture was before 1944, Her Ladyship Honorable Amrita Sinha has passed this order. Now, I just want to come to one legal point. Come to the main mat. What is the prayer? The prayer is for that the impugned judgment and order is otherwise bad in law and liable to be set aside. Come to the can application. What is the prayer? The prayer is, in the circumstances stated above, the applicant applicants most humbly pray, an order to issue staying the operation of the impugned judgment and order dated 30th September 2024, passed by the Honorable Justice Amrita Sinha in WPA 1944 of 2024. Now, if we look into both the prayers, are we not deciding upon the mat what has been the main relief we are seeking in the CAN application. Can we look into that? Now, if we come to that order portion, my lord, there are compartments in that order. Which one he wants to stay?
18.
He has to specifically make.
18.
That is why I said, what are the defects? Because my learned friend on the first day, on 4th of this month, has pressed before this honorable court that there are some defects in the Writ application, in the appeal. We want to rectify it. Now, I was served with this copy. Whatever submission I am making before this honorable court is based on this. Now, on Monday, when the matter was listed, my learned friend had said he sought for an adjournment, as I was said. Your lordship has preferred the day today. That is why my first question was, what is the defect?
We have some administrative work, Mr. Advocate.
Let it be, I will file an written opposition against it. Because by way of an interim order, the main order.
Anyway, both of you come with written notes of argument so that we can conclude tomorrow. Because there is very few.
If you agree,
it will take time to.
A very short time, you see.
If you agree, we can dispose of the appeal.
Yes, my lord.
Writ petition is
Nothing
pending.
remains because
come
after exchange of affidavit, it can be decided whether he has a merit with regards to the parties that it petition.
Sir, it is our suggestion, think overnight, mull over it. We are prima facie satisfied that the order impugned, asking for compliance of the order passed by the earlier division bench, is beyond the scope of this writ petition.
No.
Sorry, sir.
Your
If you do not allow us to complete what we want to say,
Yes, I
then it
got
is
your point. Only 18.
Yes.
Now he has to make his amended prayer here, isn't it so?
No, because we can mold the prayer. We can mold the prayer as a court of equity, as a division bench. We can do it.
I don't mind. I don't mind, but only 18, but not the entire order.
They are only agreed with 18.
But they should have written that.
Now we
what
will-
is before us, that we have to decide, okay?
Yes.
Whatever appeal is before.
We'll set aside that
It's been written
tomorrow, and we'll send it back after affidavits. Have your writ petition heard out by the single judge? We can give direction on the affidavit for affidavit.
Let it be decided on merit.
We don't want to get late.
Yes, yes, my lord.
Tomorrow. Which item number? 270. আমরা কি শুনছি এখন? Mr. Dotto, to be very frank, very difficult. Take a chance, but very difficult. And I don't want to give you false hope. It will be there, but we are not up. It's not a hearing matter. You want to withdraw it.
Respondent has also consented for withdrawal of that. The learned tribunal said no. At the instance of an advocate who was appointed by my earlier power of attorney holder, whose power of attorney.
We understand, Mr. The problem is we'll go serially. If it can is taken up, we have not upgraded a single matter in this circuit. It will be there. It will retain its position. Yes. Give the number, it will be listed with. Hello.
Grateful.